Good morning, welcome to the Lawrence County Municipal Court. I'm Judge Casper. Today's May the 6th. We have reviews to do first for people who have been before the court before and have things they're supposed to be working on. We'll review that, and then we'll start with the new cases. So bailiff is going to call the reviews. If you're in that group, come up to the table to your right. If you missed a review hearing before, you need to go check in with the clerk because we won't know you're on the dockets. We won't know you're here and you won't be on the docket until you go check in with the clerk. All the reviews.
Kimberly Jones, IDR Meadows, Travis Salyers, Christopher R. Smith, Ceylon Smallworth.
If your name was called, come forward. No. All right, Kimberly Jones is here. Are you able to make a payment today, Miss Jones?
Well, I'm not gonna make it today, it'll be a couple of days, but I've been taking care of my aunt. She had to have hip surgery, and I got 60 hours in so far in volunteering.
It has not been turned in, Your Honor. She said.
And I forgot my paper. You know how they keep track of your hours?
Yeah.
But I'll get it next time.
Turn that into Mr. Cooper or Mr. Major, and go ahead and make your payment, and then I'll set your next hearing for...
You gonna give this one? I know, bring the paper back to you.
Write down your next hearing date.
No, I'm sorry. Okay, what is it again?
June 28th.
Okay, thanks. Appreciate it. Oh, he didn't, thank you.
Okay, Heidi Meadows, case number 23-341, has been called, hasn't appeared. This is going to be a warrant issued for failure to appear. I said May the 6th before, it's May 3rd. 22-418, 22-420 is Travis Salyers, called, did not appear. The warrant issued. Christopher Smith, 23-561, called, did not appear, will be a warrant issued.
Your Honor, if I might, is he finished? He done community service yesterday.
He said cost to pay, he hasn't paid.
It must be.
Savion Stallworth, case number 23-859, has not appeared and hasn't finished, so it'll be a warrant issue. Okay, the next things are going to be the new cases for arraignment. If you're here for that, when your name's called, come up to the table to the right, stand there. I'm going to go over the charges with you. You have a right to remain silent. You don't have to say anything. If you do make statements, what you say is on the record. If you admit something about your case, it can be used by the prosecutor against you. You have a right to have an attorney if you're facing jail, and to have one appointed if you can't afford one. You have a right to bail and to make the state prove charges beyond a reasonable doubt. If you enter a guilty plea or no contest plea, you're waiving those rights, and you shouldn't do that if you don't understand the proceedings, if you want to talk to a lawyer, or if you want a trial. Any of those reasons, or you don't know what to do, you should enter a not guilty plea when you're asked for a plea. That preserves all of your rights. Call the first case.
State of Ohio versus Desiree McDaniels, case number CRB 24192. Desiree McDaniels.
Ma'am, you're Desiree McDaniels.
Yes.
Ms. McDaniels, you're charged with failure to confine a dog. So as just happened March 19th, 2024 in Fayette Township. It's a minor misdemeanor, so there's no jail time on it. The maximum penalty you face is a $150 fine. Do you understand the charge?
Yeah, I think I do. Yeah.
Do you understand the rights I explained? You don't have a right to a court-appointed attorney because you're not facing jail time, though. So you can have a lawyer if you want, but you have to hire one.
Okay. No, I don't need one.
How do you wish to plead to this charge?
Guilty.
Guilty means you're admitting it's true. You understand that?
And no, so no contest would,
No
Like-
contest means I'm not admitting it's true, but I'm not denying it either. And if you think the state has enough evidence to convict me, Judge, I agree you find me guilty without a trial and lawyer. That's what no contest means.
see, I'm confused on it, because he did get loose, but he was on a leash. He broke free from my son. I don't know. So if I say no contest, we could get it over with now?
I'm going to read the affidavit, and then depending on what you tell me, I mean, if you tell me I'm not guilty, then I'm just going to set it for a trial. But if I read the affidavit and I think that's enough evidence for a violation of the statute, and you don't contest that, then there would be a guilty finding.
Let's do no contest, I guess.
Okay. Well, you got to be sure this is you have to be sure when you enter your plea. So,
No contest.
all right, I'll accept your no contest plea. It's a kind of a lengthy affidavit, so I'm going to go ahead and read it into the record, and then you can make a statement in response if you want to. This is affidavit. It's by Deputy Frame from Lawrence County Sheriff's Office. He says, I was dispatched to an address for a complaint on a dog. When I arrived, I was met by a female who identified herself as Harley Hughes. As Hughes advised me, she came home early to clean off her back porch, and her dog out while she was cleaning. She advised she was sweeping the concrete, and she witnessed a young boy chasing what she described to be a Doberman with a brown leash dragging behind it. Advised the boy looked to be about 16, 17 years of age. The dog came towards her dog, and he began yelling at the dog, walking slow. Advised when the boy's dog came to her dog fought back. She grabbed her baseball bat. Advised the boy if his dog comes in her yard again, she was going to use it on the dog. Miss Hughes advised she went over to her cousin's husband's apartment. Can we take the children outside, please? Ms. Hughes lastly advised that she called the sheriff's office and waited outside with Billy and Michael till the deputy arrived. Went to the residence where the dog was located. He knocked on the door, male subject answered. He advised he was 14. Advised him his mother and daughter to contact the sheriff's office. On March 20th, I attempted to make contact at another address. Okay. Based upon this, I'm going to make a not guilty finding. There's not enough evidence here to warrant this charge being filed. So here's what the law is. And it looked like you were trying to do it, or your son was. Dogs have to be under control. They have to be on a leash or in a fence. They're not allowed to just run free and clear. It looked like he was trying to keep the dog under control, but it got away from him. So I'm going to dismiss the case.
Thank you, Your Honor. Is that it?
Yes, you're free to go.
State of Ohio versus Allison Littleton, case number CRB 19540.
You're Allison Littleton?
Yes.
All right, Ms. Littleton, it looks like you allegedly missed a review hearing January 20th of 21. I got a warrant issued because of that. This was on a theft offense. You admit or deny you missed your hearing?
I missed the hearing.
Do you have an explanation?
I take care of my elderly parents, and I was terrified of COVID at the time, and I was afraid I would give it to them.
Okay. It looks like you did pay your fine and court costs, but you never did the community service according to my record. Is that correct?
That's correct.
Okay. You have something you want me to look at?
There's also medical records on top proving that I've continued my mental health.
Okay.
I beg your pardon? You can.
And I believe her interest says she has to complete treatment too, so
Okay.
that's, when I looked it up, they contacted me this week and I told her to bring any proof she had that she was completed treatment.
Okay, is this, you're giving me a letter from the library. I'll turn this over to our staff and they can research to see if they want to accept this or not. And Pathways is where you're going for treatment?
Yes.
Okay, I need a letter from them saying what you've done rather than, you're just showing me that you've been there, that's all it says. So I'll return that to you. So what I'm going to do, I'll set this up. Are you not living in Ashland anymore?
I live in Ashland, but my parents are in Grayson, and that's where I spend most of my time.
Okay, so I'll cancel the warrant that had been issued for you. I'll give you another review hearing date, and you need to bring in a letter from the facility saying what you're doing and what your progress is. That's what I need to know. Are you finished with treatment? Are you still out? What's going on?
I'm
with that?
actively going to Pathways.
Okay. Send me something from them, and you'll probably have to sign a waiver for them to reveal it, but sign something so I can know some proof that you did engage in treatment as you ordered and how you're doing with it. And we'll come back in June. Let's see. I'll set it for June 24th. If you want to write that down, there's a form in the basket for your next candidate. June 24th at 9 a.m. And talk with Mr. Cooper about what he's going to do on this. She lives in Ashland. She provides something from Moorhead, Kentucky library about the community service. So I assume that what whatever he'll speak to you about it.
Okay, thank you.
State of Ohio versus Trevor Fitzpatrick, case number CRB 23-232 A and B, TRC 23-379 A and B.
All right, this is Trevor Fitzpatrick, 23-232, 23-384, 23-379. And you had a review hearing on March 22nd for this year. It looks like you missed that hearing. You admit or deny that?
Yes, sir. I was out of town for, I just got back last night.
Okay. You still have community service left to do, and you still have fines to pay.
Yes, sir. I pulled out $900 a day. That's all it'd let me pull out at one time, so I can pull more out the next couple days. Or
Okay, you did make a payment this morning. When can you do some community service?
tomorrow. I heard tomorrow's a double day, so
Okay. All right, Mr. Cooper's got you down for tomorrow. Do you know what your work schedule is going to be in the next month or so?
I know that I'm supposed to be leaving on the 10th of this month, so I think I'll be gone for about a month and a half.
Okay, I'll set your next hearing for June 24th.
Sounds good.
June 24th is your next hearing, 9 a.m. You you can, if you're out of town, I'll let you appear by teleconference as long as you're being compliant.
Okay.
You can get the link from the probation or community service here, like there's some people today hearing by teleconference. Don't, because once you miss a hearing, you got 7 days to get here or you'll get a warrant. You're just lucky you didn't have police contact. You would have been going to jail with a warrant. So, all right.
Yes, sir. Thank you.
June 24th is your next hearing.
State of Ohio versus Kayla Smith, case number CRB 23271.
All right, Kayla Smith. What's going on with you now, Smith?
Last time we talked, I was at the homeless shelter with my kids, and I ended up finding a HUD house out in Wayne County over there, and my children's father ended up finding out where it was and posted himself out front of there, and ended up going crazy, pouring a knife out. I thought he was going to stab me. He ended up getting me kicked out of there, and that's when I called my mom and asked her to come down and pick me and my kids up, because I no longer felt safe to be down here where he's at, and that's why I missed my last court date. She actually had come pick me up 2 days before my court date, and I tried to call to get it rescheduled or anything, but wasn't able to do that. Medina County, Ohio, where I'm originally from.
All right.
I did pay off my fines and everything
I
today.
do see that. I want you to go do a urine screen.
Okay.
I'll see what that shows, and if you are clean, then I'll terminate your case.
Okay.
Okay. Cooper, she's gonna do a urine screen.
Yes.
State of Ohio versus Brittany Smith, case number CRB 24171, TRD 22673, A and B.
All right, this is Brittany Smith, and Mr. Roger Smith is the attorney. Celeste, you missed a hearing about a week ago, I think it was.
Yes.
So you want to talk with her, and then we'll recall it?
Okay. Yes, Judge, she said she wrote the wrong date down. If you don't mind if I'm...
Okay, see if we can do anything on a pretrial, and if not, we'll set it up for another day. Okay, that's all the arraignments we have. We may have some more as they process paperwork. Start the pre-trials, and we'll need to go to the jail early since they have some.
Your Honor.
Okay, good.
State of Ohio versus Gage Henson. Gage Henson, case number CRB 23702. It's Mr. Scott's case. He's here.
We need Mr. Scott in the courtroom. There he is.
Judge.
This is set for pre-trial Gage Henson. He has paid the court costs, it looks like. Either of us or two. 13.
Judge, this is an older case, started out as a DV. Yeah, I believe this is pre-November of last year. We had it worked out where my client would complete a anger management class, pay court costs, fines. I believe he has paid those court costs. He started the class. The issue we're running into is he's working a significant amount. And he just told me he's working about 70 hours a week, which is a lot that he's not able to get in and finish the course. I can confirm personally that he started. I've talked to his therapist, and we have touched base on that.
I don't speak to him.
Sure. Well, we can ask for continuance and try to give you more time to get that in, or wrap it up. There's been no issues.
The report from the alleged victim is there have been no further issues, so that's good news. My understanding that Shawnee was where the counseling was taking place. So if we knew what he has left to accomplish, that might help us. Is that Shawnee Mental Health or Shawnee?
The mental health,
Shawnee Mental Health.
I'm pretty sure, yes.
So
they're hard to get a report from, in my past experience. Yeah. So how's the state want to proceed?
I think it's important to at least know what progress was made.
Okay. We'll continue it for another time period, and Mr. Henson, try to get a report from your counselor as to how things have been going. And if it's a good report, the case can probably get dismissed then. So, Mr. Scott, what's your availability about a month out?
Judge, me just 1 second, grab my notebook. I'm sorry. I assume court is not in session on the 27th?
I need a Friday.
Correct.
Okay. What about June 7th, Judge? Is it a little over 30 days out?
That's fine. June 7th will be the next hearing. Pre-trial, 10 o'clock. If it's a good report, no further problems, the case could be dismissed.
Thank you, Judge.
And there's the issue of the payment of court costs also.
Yes.
Okay. Jesse.
State of Ohio versus Harold Moore, case number TRC 23-1259, and CRB 23-550.
Judge, this one's also mine. A little bit older of a case. It's a OVI and a theft. Mr. Hill and I were discussing the OVI right before we came out here. I think there's some issues evidentiary-wise that we'd like to explore a little bit further on the OVI portion of it. Mr. Moore specifically, he's self-checked into treatment. He's doing pretty well. I know he looks much better now than when I first met him. I'm in no particular hurry to wrap this one up and would like to look at the evidentiary issues a little bit further.
Well, my notes for today was either indicates to the court there would be a plea or a trial or a motion or something. So I think this has some age. Yeah, it's last fall, September 2nd. So we need to resolve this in some fashion.
We had popped the brakes. Mr. Moore had an unknown warrant out of West Virginia. He was picked up on that, served his time, and from there self-checked into treatment. Sure. So I think this one may be right for a suppression motion. I was hoping to resolve with Mr. Hill today, but I think a motion just needed to be filed.
Two different incidents, one of which is a theft charge that doesn't have anything to do with the OVI. I don't know whether that could be resolved today at least.
Oh, we can do restitution on theft. Yeah. No issue at all. The OVI is the sticking point for us.
Yeah, it's a different day. It's very close in time, but not the same days. Just a few days separate.
Yeah, the judge might want to give you some community service on that. I don't forget what the restitution is. Your Honor, the theft itself, even though any theft is serious, there was a nominal amount, I think it was some soda pop or something. So what we would do, if you pled guilty today, we'd ask to delay the sentencing. We'll get the restitution figure, whatever it might be, and address sentencing on that when we come back for a pretrial on the OVI.
It's a case of Code Red Mountain Dew. I didn't know there was such a thing.
It's good, Judge.
I personally don't like it. My wife.
So is Mr. Moore changing his plea to the
Yes.
theft offense?
Yes, he'd like to withdraw his plea to not guilty and plead guilty to the theft offense alone, Your Honor.
Okay, and then there's going to be a motion filed on
The OVI, correct.
Okay, so we'll come back for a sentencing hearing on the theft and a pretrial on the motion to suppress. When can you have the motion filed?
Judge, I would request about 20 days to do that. I have a jury trial coming up. As far as the day of coming back on this one,
20 days to file the motion, or 20 days before we come back?
20 days to file the motion. As far as the day of coming back.
Motion to be filed by May 27th. That's a holiday, but we still file by then. And then we'll have a pretrial on everything in June. You want to do that June 7th date, because you're here on another matter then?
We can, Judge, that works.
All right, June 7th will be pretrial on motion in the TRC case, and sentencing on the theft, and the state will need to have any restitution amounts available for that.
Your Honor, what's the TRC case number?
23-1259.
June 7th.
Anything else?
That's all we have, Judge. Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
So you got this?
I got a 17 now.
State of Ohio recalls Kayla Smith, case number CRB 23271.
All right, Ms. Smith, I'll find your screen is acceptable and conclude your case. Your case is completed. No further review hearings here. Good luck
Thank you so much.
to you.
State of Ohio recalls Brittany Smith, case number CRB 24171, TRD 22673, A and B.
This is Attorney Roger Smith's case.
Hey, Judge, I was looking through the file. I've requested discovery. I've got the DVD in my file today. I'm going to have to sit down and go through it with you. If we could come back, I'm here this month, 20th, 24th, 28th, or 31.
Okay. Okay, I've got it up now. So give me those dates.
I'm here the 20th, 24th, 28th, or 31st of May.
Let's do the, well, Mr. Heel's not going to be here on the 28th, so I can keep that on. Let's do the 20th.
I can do that.
May 20th will be the next trial, 10 o'clock. I'll cancel the warrant that day.
Thank you, Judge. She's writing it down. She's got the right date this time.
All right. Yes, I got it, May 20th.
I'll call you before we get going. Yeah.
State of Ohio versus Brandon L. Call, case number PRC 24648, A and B.
This is Mr. Finley's case set for pretrial.
Judge, I have discovery's complete. I'm still in rule to file a motion. I just got the zip drive with the video on it, so I'm going through that. There will be a motion coming. What I'd ask for is maybe another pre-trial, give Mr. Hill and I time to talk. We haven't done that.
Okay, when can you file the motion?
Judge, I'll have that filed next week, by the end of next week.
Okay, so let's say by the 10th.
Yes, sir.
Motion filed, and when do you want to come back for, we'll do a pre-trial motion?
Yeah, if we can. Mr. Hill and I haven't even discussed the case yet.
What's your
24th would work, or the 31st?
24th, either of those is fine. The 31st is a lighter docket.
We'll go with the 31st then.
May 31st will be the pre-trial on motion. 10 o'clock.
Judge, I had a motion for Mr. Cole for driving privileges. I don't know if you've had a chance to review that.
Already signed in, timestamp. You can get a copy from the clerk.
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Harold Maynard, Case number CRB 23773, A and B.
Mr. Stratton's case set for pretrial.
Yes, Your Honor. Mr. Maynard has completed Bethesda. And she's on the line. There we go. The only thing left for him to do is to pay costs, and he can pay all the costs today.
I'll pay 40 on it today.
He'll pay 40 on
And
the
the
cost
first I'll
today.
pay it off.
And then on the first, pay the rest. So,
How much does he need to pay the rest of it?
The first I'll pay it off.
Okay.
so
What's the state's position on this case? Harold Maynard.
it's the one where we're dismissing what false.
He's made a lot of progress. My notes were back when we first started this, he admitted to doing a lot of beer a day.
I'm good now, huh?
Yeah, he's doing well.
The last time we were here, my notes were dismissed with costs next time, question mark.
Okay, so
So
he
he's
needs a
making-
little more time to pay the costs off, so.
He'll pay 40
Here's what
today.
it will do, since he's done well. Let's set it for June 14th. But if he pays the costs off by then, he doesn't have to appear in case to be dismissed.
June 14th.
How much is it cost?
How much are the costs, Your Honor?
Well, it would be
125 plus 25, so 150.
150 total.
Yeah, so 110 after you pay the 40 today. All right, good deal.
All right, thank you, Your Honor.
Thank you.
State of Ohio versus Heather Noel Sommer, case number CRB 24174, A and B.
That's right.
It's Mr. Stratton's case as a pretrial.
I need a video on this. Okay.
Your Honor, we received discovery on the case. We still need to get the video and review the video. So it just has to be set for another pretrial. Maybe May 31st. I heard you say that was a light day.
Yes. All right, defendant's request, case is continued to May 31st for another pretrial at 10 a.m.
Thank you, Your Honor.
You're welcome.
And then I'll email that discovery to you.
State of Ohio versus Michael Davis, case number CRB 24114, CRB 24215, CRB 24990, CRB 2428, CRB 23776.
Mr. Steyer's case, pretrial.
Well, let me think.
One thing, these seem to be a little bit in conflict. Let me have Mr. Can you have council look at these? I got two different reports. One said he started in April, got an injection, and is going to be subject to frequent screens and so forth. And then the next one is recent, just says he just started his first session May 1st, so.
No, he has, so, sorry, I wrote that. So he had completed his assessment first, and then he was last seen on in April. And then on May the 1st, he was seen again, and he started another medication. So he's currently on Vivitrol and another medication called anabusalin. So he's on two separate medications for his alcohol abuse at this point.
Okay, so, but there wasn't a lapse then, because I wondered, was there a lapse in time in April where he wasn't getting treatment, or?
So the whole thing was kind of confusing because he completed OVP Recovery Center successfully. And then before he was seen at OVP outpatient was when all of these things happened. And then he was seen at OVP outpatient and has been compliant with everything.
Mr. Hill.
Well, Your Honor, we now have, in addition to the 3 cases in which, or 4, in which Brandy Traylor is the alleged victim, and 4 times, I guess, it didn't happen. I don't know how that's possible, but we now have a young lady who is not willing to just say it didn't happen, or I don't want anything to happen. So we take them all seriously. Even if we've got a victim who is stubbornly denying that it happened or that she wants to pursue the charges, we still believe they all happened, and we are still wanting to pursue all of them. However, the reality of the situation is that we have one case that's a whole lot easier than the others. And our recommendation to resolve this, we would want Mr. Davis to do at least 30 days in jail, 6 months with 5 months suspended, in order to stay away from this young lady. That would be our, and
which case, do you know the case number on that?
Yeah, it's the latest one.
215, 24-215?
Yes, Your Honor. Now, there's also a question of whether it would qualify as domestic violence or not. She's not related and apparently was staying there at the house on a trial basis. We would be willing to convert that to an assault, but we would insist upon the imposition of at least 30 days in jail, actually served, and then probation and a suspended sentence of 5 months, and in order to stay away from the young lady that's the victim.
So just to clarify, are you saying you would want to plead to that case only?
We would do that in order to resolve the other case.
I think it might be worth having this case recalled so I can have a little more extensive discussion with Mr. Davis.
All right, this case will be recalled later in the docket to give council a chance to discuss.
Just hang tight. You don't have a lot to talk about.
State of Ohio versus Britton T. Pelfrey, case number CRB 22415.
Sure.
This is Mr. Steyer's case and set for a pretrial. Graduating today from an inpatient at OVP with a good report.
Yes, he has done very well, Your Honor.
Congratulations.
Thanks, John.
This was a case where he had pled. He missed some review hearings. Looks like he got arrested apparently on a warrant. Was the these are really pretrial reviews, so.
Yes, Your Honor.
Does the state take any position then on this?
No, Your Honor.
What I'm willing to do is basically reinstate him to his review status. I'm sure he has fines, court costs, and community service left to do. I also think with his past record, it would be important for him to continue with some sort of follow-up outpatient.
Yeah, he's following up with OVP outpatient in Huntington. We already have that scheduled for the day after he leaves OVP. And he's also done some community service at the food bank that he
Okay.
has to turn in.
So you need to talk to Josh about that, and then that'll get updated. I assume you probably haven't done enough to wipe out the entire commitment anyway, although you may have, I don't know. But if that takes care of things, obviously he'll let you know that the case would be completed, but otherwise you'll get a review hearing date.
Well, I'm going to give him a review hearing anyway.
Right.
I think he needs, I want him to continue with treatment. So, is he willing to make some sort of admission that he had failed to appear in the past?
Hang on 1 second, Your Honor, I'm sorry. Yeah, we would admit failure to appear, Your Honor.
Okay. So I'll sentence him to whatever time he served. He had served in the past, and reinstate him to the, it's going to be a sentencing because he has a bond up. So.
Okay.
Put him on the sentencing docket, go about a month out. I want him to continue, as it says he has planned, to do outpatient with OVP and get your community service done. We'll take a look at that and see what you turn in. So, it won't be necessary, Mr. Steyer, for you to follow him any longer.
Okay.
I'll put it on the sentencing docket for June 14th.
June 14th, 10 o'clock. And you may not be able to talk to him today because of everything that's going on. You may need to come in a different day, or you can wait around. You can talk to him when he gets a chance.
Okay. All right.
Anything else?
Thank you.
No, thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Destiny Pruitt, case number CRB 24103. Destiny Pruitt.
Your Honor, Ms. Pruitt contacted me earlier in the week, actually yesterday, asking to confirm that her court date was the 10th, which I looked and said, well, no, it's tomorrow. She has obtained employment, and that was going to cause a conflict today. I just got the video for this case on Wednesday and have not had an opportunity to look at it yet. So I asked Mr. Heald if he would be agreeable to a continuance. If not, I can try to get Ms. Pruitt onto the video. I asked her to be available, but she couldn't really just be on it because she's at work. But if you prefer to see her today, I can get her to jump onto the video. Otherwise, we have an agreed entry setting this for the 31st, which gives her time to ask for the day off work at the new job.
That'll be fine. I'll approve that. So, case at the defendant's request is continued for another pretrial on May 31st at 10 a.m.
Thank you.
You're welcome.
State of Ohio versus Angela Badgett, case number CRB 248.
It's Mr. Morford's case set for pretrial. Angela Badger.
Angela Badgett.
She was supposed to be seeking some counseling, pay the court costs, and then it would be dismissed. We had an initial report from OVP, March 28th. And it's not good. It's basically saying that she was terminated from services.
Judge, could you tell me when that was?
The date of The letter from OVP was March 28th.
Thank you.
So there'll be a warrant
Sorry,
issued.
Your Honor. I have a letter from OVP for her.
Okay.
I did ask her to be here today.
Is she back in services?
No, they basically completed her out from Ashland OVP.
Okay. She did some treatment there, 5 sessions, and they basically said they didn't think she needed additional treatment, but there's not been cost or anything paid.
And that's what I informed her, because she called me and was asking what to do, and I told her that she needed to show here today because she hadn't paid her fines or anything, because she told me she wasn't going to be here, but I told her she needed to be here, so.
Okay. What's the state's position on it?
In checking with the alleged victim, there have been no further issues. We would want the cost paid. We don't have an opposition to a short continuance to try to get her to do that.
Mr. Morford, do you have contact information for her?
I believe so, Judge. Yes, Your Honor.
Okay. You want a continuance then?
Yes, Your Honor, we
This
wait
is one we
time.
could set May 28th. That's the day after Memorial Day, will be on Tuesday. Because the only thing that's going to happen is she's either going to show up or not. If she shows up, pays the cost, it'll be dismissed. If not, there'll be a warrant.
Okay, thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
State of Ohio versus Jaron Bailey, case number CRB 24207.
Jaron Bailey, is this a Morford's case? And he is scheduled to complete the end of this
Yes.
next Monday. I guess it's coming Monday.
Okay. I read it. It's out of that one.
Is this Amber McCann? Okay, she's over here. You've talked to the prosecutor, this one, you talked to the prosecutor.
So in reading this letter from OVP, it sounds as if he's made some progress. He's going to complete their program on the 6th of May, but then he plans to attend outpatient services. Now, so you're Your Honor, speaking with Ms. McGann, is it McGann, is that how you say it?
Yes, yes, sir.
She wants the protection order dismissed. She says he's doing great. Our feeling is that it sounds like there's going to be a transition to outpatient, and we would like to follow that progress just a little bit longer to make sure there aren't going to be problems. So we would ask for another hearing.
No objection, Judge.
All right. At Ms. McGann's request, the protection order is dropped. Looking for dates in 1st of June. What's your schedule like, Mr. Porter?
I think I'm pretty free in June, Judge.
Let's do June 3rd, 1 month exactly.
June 3rd?
Yes.
I'm here.
June 3rd will be the next pretrial at 10 o'clock, and we'll look at dismissing the case if there's been no further problems and he gets a good report from ODP.
And the court costs.
And court costs.
Thank you, Judge.
Okay, that's all.
Thank you, Your Honor.
Thank you.
State of Ohio versus Stephen Wilson, case number CRB 24172, A and B.
Hey, Rich.
This is Mr. Morford's case. Okay, it's an excellent report.
Your Honor, Stephen is an exceptional client. He does everything he should. He follows all the rules, gives us no problems, and we are requesting to have his ankle monitor removed today, if you approve that, to let him have a chance to grow.
We want Mr. Wilson to be successful, and it's good news that he's making progress. In reviewing some of the history of this, it's our understanding that Mr. Wilson's been through common pleas court in the past and actually gone to STAR a couple times and then relapsed in a bad way. And we want to stop that pattern. And I also believe he may be on probation in Kentucky.
Yeah.
So I know he's got a lot at stake here. We want him to continue in the treatment.
Priscilla Carter.
You're stupid.
So, Your Honor, Ms. Carter is here. She's the alleged victim in this, and she wants Mr. Wilson to get well. But this is serious, has been serious. He's built up a record of this kind of behavior, and we're not going to take the possibility of jail off the table unless he follows through and gets it done. We want to be able to leave this situation with little or no fear that it's going to be any kind of thing like this in the future. So hopefully he's working hard towards that.
Judge, I too want to see him succeed in his counseling. Shawnee is singing his praises. He's bought into the program and is making progress. I'm sure he'd like to be finished with this, too.
And Ms. Carter, what relationship are you to Mr. Wood?
I'm his mother-in-law.
Okay. He has children with your daughter? No children? Was the problem alcohol, drugs, both?
Alcohol. He kicked the drugs so easy. He done so well for so long.
Okay.
I don't know what happened, but
So he's capable of doing this?
he is. When Stephen is like this, he's an awesome person. Love him to death. And it's never been about him going to jail. It's about him getting the help that he needs.
Okay. Well, just an observation is sitting here for many years and watching people and seeing it and take it for what it's worth. There are certain people that I see that alcohol does not mix with them. They become a different person when they consume alcohol. And it appears, from first blush and what I see, you may be one of those people. So you have to make, in my estimation, you have to make a commitment that from now on, I'm not touching this stuff.
I understand.
And I think that would cure a lot of your problems. And the latest data that's coming out, they used to say that a little alcohol was actually good for you. It lowered your LDL or your bad cholesterol and certain things. Now they're going the opposite on that. The latest data is there's no amount of alcohol that's good for you. So even social drinking is not helping you. But you appear to be one of those people that can't social drink because you're going to wind up consuming too much, and then you become a angry. Some people get happy when they drink. You look like you're one of those people that get angry drunk and start fighting, threatening other people, and so it just can't happen anymore.
I understand. I've had a lot of stress going on too.
Yeah. Well, you have to find another place to deal with it other than alcohol's not going to be the way for you to deal with it. So you got to find another way and just make a commitment. I'm not touching this stuff anymore. I think that's the solution here. And you can do it. You've done it, and you're doing great. So I don't want to be all negative. I'm encouraging because I think you can do this. Everybody says you can, but I just want you got to mentally say to yourself, it's not something I can fool with in the future. You know, because people will play off of it for a while and they think, what would it hurt if I have a drink or go out with some of my friends to the bar and have a few drinks? Well, it can hurt a lot. So you have to be one of those people that says, nope, not anymore, I'm not doing it. That's my assessment of the situation. So,
Your Honor, if I may speak for a second. If everything's fine, it's okay with Mr. Hill, I was willing to plead guilty for a sentencing today. I can make an offer if y'all are interested.
I'm really not interested because I want you to continue on your treatment and I'll send you after I see, you may not even get a conviction.
All right, thank you.
It's possible, I don't know what will happen, but I want to see you continue. You're doing what you need to do, and I want to encourage you to keep doing it. I don't want to be negative about it, but I also want to put up that warning. This is just what I think where you are. You can't just say, well, I'm going to get through this, then I'm going to go back to the way I used to live. That's not going to work. So, I will remove the ankle monitor as was recommended. We've got lots of other people that are standing in line to get one, so take it off you and it'll go to somebody else. And then let's come back in another month. Let's see where we are. June 3rd.
That's good, Judge.
Pre-trial June 3rd at 10 o'clock.
Thank you, Your Honor.
All right, thank you, Judge.
Thank you, Judge.
State of Ohio versus Alpha Donnelly, case number CRB 2457.
Mr. Morford's case. This is one we moved up to the, it had been set June 10th.
Why did you move it up to today? Because he has to work.
He wants to go back to work.
May we approach, Your Honor?
Yeah. All right, we'll recall this later in the docket. The state's going to try to get a hold of the complaining party and see what their position is.
State of Ohio recalls Michael Davis III, case number CRB 24215, CRB 24114, CRB 2490, and CRB 2458.
Your Honor, Mr. Davis would like to have an opportunity to consider the offer. So I'm going to ask to continue this one more time, and then at that point, if we don't get it figured out, set it for a trial date. I think one more continuance would be fruitful prior to setting a trial date, but I would obviously leave that to the court's ultimate discretion.
And that's, it's understandable. I mean, we're asking, we're recommending that he do some jail time on this. However, after the next time, we're not going to hold that offer open anymore. We're going to go for convictions on all of them and ask for the maximum.
Okay. Well, we can set it for another pre-trial without, court is public, so you're always welcome to be here. Anybody who wants to come to court at any time can do so. But in this particular case, the complaining parties wouldn't be necessary for them to be here if they don't want to be, or you can actually watch court on YouTube. If you want to see what's happening with your case. You don't have to be here in person, you can watch it on YouTube. You can attend by teleconference if you want to give input, or be here in person. So I will continue it to give the defendant time to consider the state's offer, and then, so we'll need a decision then at that next hearing whether that's going to be accepted or we're going to set things for trial. So, probably going to be at least a couple weeks. Yeah, we can do 17th or at any time thereafter, Mr. Dyer. What's
23 weeks. 24th, Your Honor.
All right, May 24th will be the next pretrial. There'll either be a plea or a separate trial.
And, Your Honor, couldn't do anything but help Mr. Davis's cause if he would make sure that Lindsay gets her stuff out of the house, which we spoke about last time, and apparently it hasn't happened.
Hang on. What are you saying?
They were supposed to have done that last time before I even come to court, or when we were leaving for court. It's just where they went.
Is that what?
Yeah.
Well, that's not, we're not worried about that right now. The home belongs to Ms. Traylor, so Mr. Davis doesn't have anything to do with the issue other than if they let him know when it's going to be, he can leave, but it's not her, it's not, he lives there, but it's not his home, so he's not in control of that.
We got two people that can't, one of the people that's not the complaining party come over and pick up, they can have it ready.
Right.
Yes, I can do that if they just text me and let me know when they want to come get it. I can
Well,
pick it
let's
all
just set a
up.
date right now.
Can my brother go do it? Because he has a house key. But the only thing I really need are shoes, because I'm down to one pair of shoes.
Well, let's just have them get what they say is yours.
Okay.
Put it someplace where his brother can come and get it. And then if there's some dispute about, well, this was mine, you didn't give it to me, you'll have to go to civil court or something. I can't, I'm not going to be able to divide the Tupperware. It's one of the first, way back, I'm old enough that when I first started practicing law, there was actually Tupperware. I was practicing in court in Florida, and the judge said, get out there and settle these divorce cases, and I ain't dividing the Tupperware either. So here you go. That's why I always have to say that I ain't dividing the Tupperware. But you guys work it out as much as you can. If you can't, then you have to go to civil court over the property. Okay, so we're coming back on May 24th. Hopefully by then, that's sorted out, and we'll decide whether we're going to have a plea or a trial. You're welcome to be here. You don't have to be here. Mr. Hill.
One other thing, Your Honor, and actually I was thinking that all the charges had to do with domestic violence, but there's, under 24 CRB 90B, there's a resisting arrest.
Your Honor, Mr. Davis pled guilty to that a long time ago in exchange for an agreement that the cases regarding Ms. Traylor would be dismissed. I think Mr. Hill decided not to go with that, so I don't know where we actually stand on that at this point.
Well, there were further problems. He got apparently 30 days suspended, and then there's been further problems. I don't know whether he's still on probation or not.
We'll take that all up on the 24th.
Thank you.
Thank you. Okay, I'll see you on the 24th.
State of Ohio versus Hunter Smith, case number CRB 24158.
All right, Mr. Woodyard is here representing Hunter Smith, set for the trial today.
Your Honor, discovery is complete in this case. We've had some preliminary negotiations and would just ask to continue this date or set another pretrial date to give us a little more time to advance our negotiations, see if we're going to be able to resolve this or would need to set a trial date at that point.
Okay, the 17th of May or after is what I'm looking at in terms of.
17th good for you. Your Honor, the 17th of May is good for me and my client.
All right, I'll set the next pretrial for May 17th, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you, sir.
You're welcome.
State of Ohio versus Antonia Caldwell. Case number TRD 24643 A and B. Antonia Caldwell. I couldn't hear you. What did you say, sir?
Antonia Caldwell.
Caldwell. Caldwell.
Caldwell. Antonia Caldwell. Set for pretrial today. Has not appeared. There'll be a bench warrant for failure to appear.
State of Ohio versus Joshua T. Davis, case number CRD 2471.
All right, this is set for pretrial. Mr. Davis, do you have a lawyer?
Brittany Evans. All that around.
State want to proceed.
Well, I'm looking at this report I've got here, and it turns out it's about Ms. Davis, the one I have.
I have one also as for from where I went to the therapy.
Yeah, I'd like to see that, please. Judge, you may want to see this also.
All right, Ray will come and get it.
Yeah, she's not recording, she's just doing it on her own. Yeah.
Need a copy for the court's record.
And we need one too, Ron, please. So, Your Honor, from the beginning, there's been an effort to try to improve the lives and the relationship of these two individuals. And the letter was that from Huntington?
Some association with cattle.
So it gives the impression anyway that Mr. Davis is doing really well. But Mrs. Davis also has attended some of those and feels that it's not as shining as that letter gives the impression of. And she's urging me that there's nothing more that we can do for them, but that things have not gotten better. And I'm not convinced that just saying, okay, we're done with this is the right way to go.
Yeah, I mean, the facts in the affidavit are pretty bad.
Yes, and
You just said it was wrong.
well, my suggestion was going to be that they both agree that to take a different direction as far as counseling and try something different, a fresh approach. We would prefer that to the trial.
I don't want it to go to trial. I wasn't satisfied with our marriage counseling, which it wasn't ordered. It was just, it happened to be the same counselor he uses personally for his individual counseling. I can't say what happens in those sessions because I'm not there. I do just ultimately want it to be over with. It's just taking a toll.
Well, I understand. My concern is different.
Yeah, I understand that.
When a case is filed, I have a sworn duty to uphold the law and decide the case fairly and impartially in accordance with the law. And some cases I look at and the affidavit is not that serious, really. This is serious business, what's alleged here. So I don't feel like I can just say, oh, go your way, we'll just ignore this. If something else happens, someone the community might legitimately look at me and say, Judge, you had this in front of you and you did nothing with it. Why? So I'm not going to do that. Mr. Davis, you don't have counsel. You need counsel. And I take it you don't have counsel because you don't want to spend the money, but you are employed at Catalina Hospital, is that right?
No, I'm employed at Rubber Light. I'm just under the influence that from the first day I was to go do some therapy in order to get this behind me, and I've done all the therapy and I came back, the letter wasn't good enough, and then this time I got I've been going to therapy. I thought, to my knowledge, that was the punishment, was going to the therapy.
Well, you haven't pled, as far as I haven't made a note that you pled not guilty, correct? Is that a yes?
Yeah.
Set it for trial. We're going to set it for trial, and I'll make a decision then whether you were guilty or not guilty, and then I can enforce whatever punishment I think is appropriate or counseling or whatever I need to do. So, I'll set it for May 31st at noon for a trial. Anything else? May 31st, 12 p.m. It's the next hearing. That's all. Free to go.
State of Ohio versus Larry Tickner, case number CRB 24249.
Sir, you're Larry D. Tickner.
Yes, sir.
The bail's about to hand you a copy of the charge. The charge alleges that April 30th, Fayette Township, while being under the influence of alcohol or drugs, you used or abused a firearm or dangerous ordinance. So the charge against you is having a weapon while intoxicated, using a weapon while intoxicated. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead to this charge?
Not guilty.
Do you want to be considered for a court-appointed attorney?
Yes.
Do you have a job?
Excuse me?
Do you have a job? Do you
Yes, sir.
work? What do you do?
I do maintenance.
Maintenance?
Maintenance.
Do you work for someone or you?
Yes, yes,
you
I do
work?
maintenance for McDonald's.
Are you paid by the hour?
Yes.
How much per hour?
17,
How many hours a week do you work?
35 to 36. Been there 29 years.
So you're making about $31,000 a year gross, is that right?
Roughly, yes.
Do you have anybody that's dependent on you for income?
No.
Okay. Well, you make too much money for a single person for me to appoint a lawyer for. So you have to hire your own lawyer. I can't appoint a lawyer for you. How much time do you need to get a lawyer? Do you have a time frame you need to get a lawyer in? Okay, I'm going to continue it for 3 weeks to give you a chance to get a lawyer. So that's the 24th of May. May 24th, write that down. There's a form in the basket there right next to you. Write down your next hearing date. Thank you, Mr. Smith.
Yes, sir.
May 24th at 10 o'clock will be a pretrial. Not guilty plea is entered. He has a bond up with Sowards. And I will put down that you will hire counsel.
Yes.
Okay, that's all.
State of Ohio versus Douglas Hess, case number CRA 2473, CRB 2474. Your Honor, set for preliminary hearing.
Douglas Hess is Mr. Morford's case. And I think,
Yes, he's the one, Your Honor, who had ran away from OVP.
okay.
So he has not returned, and he also has not followed up with OVP anywhere, so he's in the wind.
We do still have an active warrant for him.
And this is a felony. So, let's see what the felony is. Well, he's got theft, a misdemeanor theft, and he also has
Possession.
F5 possession, methamphetamine. And he was at OVP, and he left treatment against medical advice.
Yes.
So does the state want to take it to the grand jury or keep it here? And he has a West Virginia address.
Well, we don't have a problem with keeping it here. He pled to the theft and hasn't been sentenced on that, so the court may have an interest in wanting to sentence him on that.
Okay, I'll issue a warrant, which I think has already been issued.
Well, there's currently a warrant.
Should be a warrant on the felony, so we can get jurisdiction in West Virginia to get him arrested over there.
There's a bond forfeiture warrant, Your Honor, from April 9th on the felony from where he left treatment.
Oh, does he have a bond though?
Yeah, he left, and then he came back, and then he jumped the fence and ran again. So he hasn't been very compliant.
But I think it was an OR bond.
Revocation warrant, maybe it was just put in the computer as bond forfeiture when it should have been bond revocation.
It was an OR bond, so unfortunately, we don't have Mr. Sowers to go fetch him. But let's make sure it's on the felony so that we've got, okay, so it'll be good in West Virginia. All right, we have more issued from this court.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
State of Ohio versus Aaron Sloan, case number CRA 23-368 A and B, CRB 23-369, TRC 23-750 A and B.
Okay, I've got a letter of completion from Mark. So, she had felony cases, which could be dismissed if the state wishes to. She's pled to the ODI, was sentenced on that. Case numbers on the felonies are 23-368, A and B. There was a 23-369 too, which was a misdemeanor.
No, I think those were already dismissed.
Okay.
Your Honor, may I, real quick? We did this not the last time I was here, but the time before. You had gotten the letter and stuff, but he brought it up on his phone because it wasn't sent, and you read it off of your phone. So the last time I was here, you said that I didn't have the completion and all that, and I was so confused. But I had him find it so that it could be put in the folder. But we'd already done that, I thought, and dropped. I thought you'd have to tell me if that's what you have or not too, but.
All right, the felonies are already dismissed. You have to complete your ODI sentence.
Right. And the only, with my community service, I don't want to get up here and give you a bunch of excuses, but my problem was with my children, and I live over in Kentucky, trying to get them to school. They don't have to be at school until after 7:30, but I've got it worked out for next week to where I can be here and get it all done next week.
We have it on Saturdays too.
Okay.
You do tomorrow, you get double credit.
Yes. Tomorrow is?
Okay, so we're going to go to review hearings now. So I'll set a review for you. Are you working?
I'm not, no.
Okay, so it doesn't matter if it's Monday or
No.
Friday.
I work from home. I'm a seamstress, so I do stuff at home, so it doesn't matter now.
I'll set your next, your review hearing for June 7th, 9 o'clock.
Thank you.
Once you get your community service and funds completed, you don't have to come out.
Thank you.
Thank you, Judge.
You're welcome. Okay, we're going to call some of the folks in custody.
State of Ohio versus Oscar Tremese, case number CRA 24-231, TRD 2010-40, TRD 1930-82, A and B.
Hey, Your Honor, just I couldn't let you know what's going on before we get in here. Judge Ballard didn't have court this week. He's in front of Judge Ballard on the 8th. So I've checked the docket. He's actually scheduled for the 8th. Mr. Hill and I had talked talked about continuing this matter out a little further to find out what's going on, how much this court before the decision was due here. But at the moment, the case is going to be taken in front of us.
So you want to come back the 10th then?
Let me make sure I'm available to attend. I think I am, just make certain. I am already on the document, so yeah.
State agree with that?
Yes, Your Honor.
All right. Mr. Cremeen's case is continued to May 10th, so we'll have him here after he's appeared in common pleas.
All right.
Next hearing, May 10th.
So no warrant here?
I'm sorry?
Can we get a warrant here today?
No, we're just setting this out to the end. Oh, actually,
I think I already said an OR.
Yeah, you've already got an OR, but that case has to be done before we get out.
You're being held by common pleas.
Okay, thank you.
State of Ohio versus Douglas M. Dillon, case number TRD 212133.
Yeah. Douglas Dillon. Douglas Dillon? All right, Mr. Dillon, it's alleged that you missed a review hearing June 23rd and 23 last summer. Got a warrant issued, and it looks like you got picked up on the warrant. You admit or deny you missed that hearing last summer?
Yes,
Do you have an explanation for missing?
I was working in Pennsylvania, going on, no speech from this agreement. We were at a time that I had gotten moved to the Deer Lake area, and I hadn't had an agency for a year.
So, how'd you get arrested on this?
I was speeding.
Here in Lawrence County?
Yes, sir.
Did you get a ticket on that?
No, Your Honor.
They just took you to the jail?
Yeah.
When was that?
When was that?
When did that happen?
2 months ago, Your Honor.
I have you living in St. Albans, is that where you live?
I did, Your Honor, but I actually moved back out here.
Is this where you're from originally?
Yes, sir.
Where?
South Point.
Okay, makes sense. Okay. Well, look, how old are you, Douglas?
32 years old.
Man, you should be old enough to know better. Because what happens if you have a court date, you knew you had a court date last summer, right?
Yes, sir.
And when you don't come to court, what happens?
You get a warrant.
You get a warrant, it's like hanging out there. It's just hanging out there waiting to drop on you. Okay? And you knew that, right?
Yes, sir.
Then how fast were you driving?
4 or 5 miles an hour over.
Enough to get pulled over. Weren't you scared? I'd be scared if I knew I had a warrant, because if I have police contact, guess what? They're going to get on their little computer and say, "Oh, Douglas missed a hearing. He's got a warrant." Now you're not just getting a ticket; you're going to the jailhouse and wearing orange. And this has already happened to you once before. I see a judgment after this happened before, right? This matter came before the court for failure to appear for review hearing. The court sentences the defendant to time served. New review hearing set for June 23rd. Guess what? You didn't come June 23rd.
To be honest, Your Honor, I think I paid the ticket, and all I had left to do was community service.
You paid $385. You got $100 you still owe, and you owe 3 days of community service. So what do you think? I was just going to say, that's okay, Douglas, you don't have to do all of it?
No, Your Honor, I did not.
I'm trying to figure out your thinking. Why would you know how the process works, you know you're gonna get a warrant, you don't come to court, then you're speeding, then you go to jail for a couple days. This doesn't make any sense, man. It just doesn't make any sense.
I just started a new job, Your Honor, and my son's getting ready to start doing free time. I'd be more than happy to do anything.
Your son's getting ready to do what?
My son's getting ready to start doing free time, Your Honor. I just started a new job.
And you messed all that up by not coming to court, and, I mean, it just doesn't, I don't get it. I just don't get it. And what kind of job are you working?
Landscaping and home renovation.
Okay. And you're gonna be living with your son in South Point?
Yes, Your Honor.
You still owe 3 days of community service, and you've never done 1 day yet, right?
I believe that's true.
Yeah, okay. I mean, I don't want to put you in jail, but you just keep begging to go to jail because you won't do what you're supposed to do. I mean, do you understand?
Yes.
I have no choice. So, do you want to lay this out, the rest of this out in jail, or do you want to actually do what you're ordered to do?
I will do anything to make it right, to get my son to stay away, to keep me calm and started on it.
Okay. That's a good answer. But you need to have a little bit more fear and respect when you get out. You know, you miss a hearing. I mean, if it was me, one, I wouldn't miss a hearing. But you know what? I've been a lawyer too. And sometimes as a lawyer, we got all these hearings scheduled. Especially if I was going to Scioto County when Judge Burton was down there. And it's like, oh my gosh, am I late for this hearing? Did I miss it? It's on the wrong date? Because you know what? He would put lawyers in jail for being late. He would put lawyers in jail for missing hearings. So I'd be like nervous about it. I'd be like, I'm getting there at the right time. I'd check on it, make sure I've got the right date, the right time. Here, you blew this off for a year. Just driving around, speeding, not caring. Nothing's going to happen to me. Is this making any... We're like looking at the same thing with two different eyes. You know, I just don't see... I visited that jail, man. I'd do anything to stay out of that jail.
It's awful, Your Honor.
It is awful.
It's awful.
So, you got to pay attention, man, and do what you're supposed to do. And now you got your son,
Yes, sir.
and you can mess him up by not being there. Start being a man. Start paying attention, doing what you're supposed to do, when you're supposed to do it, how you're supposed to do it, and don't make excuses.
Yes, sure.
Okay, end of sermon. I'll send you to time served for not coming to your hearing last June. And let's see, I'll set it for June 24th, so we're real close to a year. And in this, so you got over a month, almost 2 months before you got to come back. You've got 3 days community service, and tomorrow you can get 2 days credit by doing 1 day of community service because we're doing a township cleanup. You got to be here at 7:30. Is there another day where we're giving double credit coming up? Okay, tomorrow is the last of the double days for a while. There might be more coming up. But you got to do your 3 days community service. You can do it any day but Sunday here at the court or a holiday. We got a holiday coming up, Memorial Day, so there won't be community service that day, but every other day, right here at 7:30. Pay off your $100, and then you can quit worrying about this. Get it off your slate so you don't have to worry about it. Okay. You got to come back June 24th if you don't have it all done, and if you don't come back, what's going to happen?
I'm going to go to jail.
I'm going to issue a warrant, and then you'll go to jail whenever you have police contact. Unfortunately, I wish they would go hunt you down as soon as I issue the warrant, but for missing a review hearing, they don't. They just let it lay there, and then you never know when you have to look over your shoulder all the time. Okay.
Thank you for the opportunity. Thank you very much.
Okay. Make it right. Take care of your son. Do what you're supposed to. Follow the rules. Okay? All right. You'll get out later.
State of Ohio versus Corey Easton, Case number CRB 24-242, CRB 24-222.
Okay, so you're Corey Easton. Did you get a copy of your charges? Okay. Well, I've got an extra copy. There's that one, and I've got another one.
What was her case, 24-247, what was the other one?
24-222. Needs to stay. Okay, 24-247 alleges that on April 30th, without the right to do so, you entered on the premises of another person. That's trespassing. It's a 4th degree misdemeanor. Maximum penalty, 30 days in jail, $250 fine. 24-222 is menacing, aggravated menacing. It alleges April 15th, you knowingly caused Jennifer Craig to believe, I think this needs to be amended, it's got the wrong name. Look at 24-222.
I don't have that one in front of me, Your Honor. Is that from the one I have, the trespasses from April 30th?
Yeah, this is April 15th, aggravated menacing.
And there needs to be, if there needs to be amendment, we'll have to get the file out to do that.
I think they maybe copied it from another case and still have the other defendant's name. It says David Fetty in the body rather than Corey Easton.
Well, then we would move to amend that name.
To Corey Easton?
Yes, Your Honor.
Okay, I'll allow the amendment. So it's alleged that you caused Jennifer Craig to believe you were going to cause serious physical harm to her person or property. All right, Mr. Smith, I'm going to appoint you to represent Ms. Easton. What's the state's position on bond?
Well, Your Honor, the facts of this criminal trespass case are a little unusual. I don't know what the underlying issue might be. Looks to me like the allegation includes some indication that there may be substance abuse involved. This has to do with a trespass on the property of Hometown Recovery. She wasn't apparently a resident there, but was kept going there for some reason.
Why don't we, Mr. Smith, why don't you talk with Ms. Easton, and then we'll come back and decide how we're going to proceed with bond. Here's, you have the court's file.
State of Ohio versus Eddie Eastep, case number CRB 23-203, GRC 21-269, GRC 17-442.
All right, this is Mr. Morford's case, pretrial review. Eddie Eastep. He's on a warrant for failure to appear at a pretrial back in, about a year ago, April 28th. He had a pretrial according to the record and did not appear. Got a warrant issued, looks like he got arrested on that. He has some old cases too, an OBI that he was previously convicted on, and two OBIs. So those are not completed. The 23-203 is a possession, misdemeanor possession charge that's still pending. So you'll have to stand in line to get in the attorney room and then talk with Mr. Eastep, and we'll have him come back out after that's out. Thank you.
State of Ohio versus David L. Fetty, case number CRB 24-140, and CRD 23-1820, A and B.
All right, sir, you're David Fetty.
Yes, sir.
Have you received a copy of the charges against you?
Did driving charges and
Aggravated menacing?
that was the 22nd hour. I wound up going to the hospital on that court day, sir.
Okay.
I was in St. Mary's there for a while. And I had a real bad infection. But they said I'm in here over, when they got me on, driving back in December. Traffic.
Yeah, but they staple floor out here.
Yeah. We're going to talk to him when they want. He had not yet go to just got hospital.
There's a copy of the charge.
If I can get out today, sir, I'll be able to pay most of it off.
All right, Mr. Fetty, you got a charge from February 22nd of this year. It's alleged that you at Fayette Township caused Kenny Ingalls to believe you had caused serious physical harm to his personal property. That's a aggravated menacing charge, maximum penalty 6 months in jail, $1,000 fine. You have a right to remain silent. You don't have to say anything. If you do make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You understand?
Yes, sir.
How do you wish to plead to the menacing charge?
No contest.
No contest means you don't want to fight it?
No.
You're agreeing you can be found guilty if I think the state has enough evidence to convict you?
Yes, sir.
Okay, Mr. Hill, do you have a report on that? That's 24-140.
I do, Your Honor. And this is from Deputy Barker. And he says that on February 22nd of this year, he and Sergeant Sisler were dispatched to 295 Township Road 1019 for threats. I arrived along with Sergeant Sisler and began to speak with Kenny Ingalls, who stated that David Fetty had threatened him. Kenny stated that David had arrived to talk to his mom, Nancy Holly, about his dog that she was taking care of. Kenny stated that David had gotten mad, and when he was leaving, he threatened to kill him. Kenny stated that he was in his yard, it was fenced in, and David was in the street. Kenny stated that David had pulled a knife out and threatened to kill him. Kenny stated that he also had a knife on him that he pulled out also. Kenny stated that David had also threatened to burn the house down. I asked Kenny if David had threatened his mom, Nancy. She stated that he did not know that he was not in the room with them when David was talking to her. I began to talk to Nancy. She stated that David was talking to her about his dog and that she did not hear him threaten her, but also stated that she's very hard of hearing. Kenny stated that David is staying with a relative, and it is the second trailer from Burlington Park. Sergeant Sisler and I went to the trailer to talk to David. He was not there. We went to patrol around the area to try to locate David due to Kenny saying that he was walking, and we could not find him. We then went back to Kenny and told him that we could not find David. Kenny stated that he wanted to file a report of the incident, and I received a written statement from him and gave him the victim packet. Should I read Mr. Engel's?
Sure.
Okay, so this is from Kenny Ingalls. Dave Fetty threatening my mother and home, said he going to burn down my house. He pulled a knife, me, threatened to kill me. He said I was having the devil come out of him. He said and done and doing all of this because of his dogs and a something girlfriend, Alexis' niece. He's been saying he's going to kill me for about two weeks now. There's a lot more to say, but I can't write it all. I'd rather talk or tape it all.
Okay, what do you say, Mr. Petty? You have anything you
never
want to
threatened, never burned down his house. I never been threatened but once. Yes, I didn't leave that day. I went to Huntington, and then me and my dad was over to the cemetery, had a cut in the family lot. I went to talk to him. Well, he pulled a knife on me in the cemetery. He did cut me twice, but, and then I did hit him at one time there, and that was into that, and I didn't talk to him, seen him since. I stay away from him.
Mr. Hill?
Well, we have a little bit more information. It might have to do with the cemetery incident. Mr. Ingalls called our office, and he says that, and this was on April 19th. He says he was assaulted by Mr. Fetty 2 weeks ago, which would have been the beginning of April, at Burlington Cemetery. And he just got out of the hospital a few days ago, plates in his head and brain bleed. He was in the hospital for a week in ICU. We encouraged him to make a report. We haven't received a report yet. So there may be more to this. It sounds pretty serious.
Okay, Mr. Fetty, are you working at all?
I was on security, but I'm getting ready to get a job. I have a job waiting on me, but I can't come in here.
Okay, I'm going to appoint Mr. Scott to represent you. I'm going to enter a not guilty plea after hearing everything. I think there needs to be a bond. The state have a position on the amount.
State has four.
If I come over today, sir, I can pay something on.
I heard that before.
No, I got my case.
Sir,
Wait,
I heard you.
We've asked for a $7,500 cash and surety bond.
I'll set bond at $7,500 cash for surety, and one of the reasons is he had failed to appear previously. He was cited in and failed to appear, and he also failed to appear for a review hearing on, which is another matter that's pending, a traffic matter, 23-18-20. That was March 28th. So he's got a prior record of felonies here. So, Mr. Scott, we'll probably need to set this pretty soon.
I'll agree, Judge.
What's your schedule?
The suicide back here is the 17th.
That will set it then. May 17 will be the next hearing. Pre-trial at 10 o'clock.
And we're requesting a protection order.
Will be in order to stay away from Kenny Ingles, TPO. Okay, you can talk in the attorney room later.
Ohio versus Kyle W. Hopkins, case number CRA 24245.
Sir, you Kyle W. Hopkins?
Yes, sir.
Mr. Hopkins, I'm Judge Capper. This is a arraignment hearing on a Rule 4 hearing. And what that means is it's alleged that there's a warrant for your arrest from Meigs County Common Police Court, Pomeroy. You have a right to have a hearing and to have a lawyer here to determine if you are the Kyle W. Hopkins they seek, and if I should order you to go to that jurisdiction on this warrant. The warrant's alleged to be on a felony 5 failure to appear. So I can appoint you a lawyer if you qualify. We can have a hearing on it, or you can waive the right to have such a hearing, and then I'll set a bond. If you can post a bond, I'll let you go turn yourself in Meigs County. If you cannot post a bond, I'll order Meigs County authorities to come pick you up, and I'll give them a reasonable period of time in which they have to do that.
If you need your order, I'll go there straight today.
Okay?
I promise that.
I'm probably not going to give you an OR bond, but I'll give you a bond. They don't give me a lot on what the, other than it's a felony 5, so that's a low-level felony. I'll set the bond at $2,000 cash or surety, which means probably $200 to get you out. Is that a bond you think you could post?
Yes, sir, it would be, but it would be like the 8th before I would be able to.
Well, they probably would come pick you up before then.
Well, I mean, I probably mostly get it before then, but when I get paid, if I still have my time when I got out. But the main thing of it is my girlfriend, I take care of her. She has a lot of mental problems, but she got manic depression and anxiety, and stuff like that.
Do you want me to appoint you a lawyer out of this court? Or consider it, I don't know if you qualify. What are you doing for work?
Just odd jobs, that
How much do you make in an average week?
$500 to $800 or so, it just depends on what it is.
You're doing pretty good then.
I do lawn care and landscaping and stuff, and then I do just anything.
Do you have any money saved?
Not right at the moment, because I've been staying over here to try to get some tips. Me and my girlfriend was just walking to Dollar General up there the other day, and they...
I'll appoint Mr. Morford to represent you. Let him talk to you about this and decide if you want to have a Rule 4 hearing or if you want to wait. He's got a Meigs County, allegedly a Meigs County felony 5 warrant. We'll recall it after you talk to your lawyer.
We'll recall it today?
Yes, sir.
Okay. Thank you, sir.
You're welcome.
State of Ohio versus Sean F. James, case number CRA 24246.
Sir, are you Sean F. James? Mr. James, I'm Judge Capper. This is a extradition hearing. So you have a right to remain silent. You don't have to say anything. If you choose to make statements, it's all being recorded. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail. Do you understand those things? It's alleged that Greenup County, Kentucky District Court issued a warrant for a Sean F. James with the date of birth of December 17th. So Ohio's alleging you're that person. You have a right to an extradition hearing. That's a hearing to determine if you are the person being sought by Kentucky and if there's a good reason to send you there. You can have an attorney appointed to represent you if you can't afford one. It's not going to be on the issue of whether you did or didn't do what Kentucky is alleging, but whether there's good reason to send you to that jurisdiction. The charge over there is some sort of theft by unlawful taking, more than $1,000, less than $10,000. They're alleging it's a Class D felony under Kentucky law. Do you understand what I just explained to you? Do you want to have an extradition hearing? Do you want to have a lawyer appointed here? Do you want to waive extradition and go to Kentucky? Okay. You need to sign this waiver that says you're waiving your right to have an extradition hearing and agreeing to go to Kentucky. Okay, they're saying the actual value was between $7,000 and $8,000. So what I'm going to do, I'll set your bond at $8,000 cash or surety. If you can post that bond, I'll let you go turn yourself in Greenup County. If you can't post the bond, I'm going to order them to come pick you up, and I'll give them a reasonable time in which to do it. Do you think you have any interest in trying to post the bond, or you want me to just tell Kentucky come get you?
Yeah, let's try the bond.
Okay. You want to talk to bail bondsman then?
And you can go down and call them after a week.
Okay.
Yeah.
Well, we can have the bail bondsman would help you in that, so we'll need to. Oh, you don't want to try to this one? Okay. All right, I'll give them a week to come pick you up. Usually that's close, so it shouldn't be a problem. I'll put you on my docket for May the 10th for a pretrial at 10 o'clock. If you're still sitting in the jail, I don't want to lose you. I'll find you're going to be there. I'll have a hearing. Why are you still in our jail? So Greenup County should be notified he's available to be picked up, and they need to do it before 8 a.m. on May 10th. Do you have any questions, sir? Okay, that's all.
State of Ohio versus Branson Johnson, case number CRB 21795.
We got Branson Johnson.
Sir, are you Branson Johnson? Yeah. Mr. Johnson, it's alleged you missed a review hearing on March the 8th of 24. It was on a theft conviction, case number 21795. Do you admit or deny you missed your hearing?
Yeah, I was incarcerated.
I'm sorry?
I was incarcerated.
Oh, where were you incarcerated?
Remember when I signed my roll forward last time I was here in Pike County?
Pike County?
Yeah, and they took me to go, and they're supposed to correspond with you.
Okay.
I've been up there, I ain't been out of jail.
You haven't been released yet?
No, I've been down since what, February 1st.
At one point, I was ordered you to go to treatment, so that never happened because you had orders?
No, she's been there every one of my, Shawnee, they've been there every one of my court days. You know what I mean?
Okay.
Yeah, she is, yeah.
So are you finally in a position where you can go?
Yeah.
And Leslie, are you still willing to, this is Branson Johnson. He's had holders from various counties, it looks like.
Yeah, Pike County told me that when he was released from them, that they would call me. And I went to his court dates when he was going there, but they never did. They said they were holding him for the entire time, and I never heard anything else.
Yeah, I did my whole time, and they rode me from Gallipolis, where they had me, to here. And I've been down here for what, 3 or 4 days? Yeah.
Okay, so, and do you still want to take him, or do you want to assess him?
Yeah, I mean, I have an assessment for him, like I can take him whenever
Okay, I'll order Mr. Johnson released into the custody of Shawnee for treatment. Come back here for a review hearing, June 3rd, so 1 month. I'll see you back here. Good luck. See you in a month, 9 o'clock, June 3rd. He can be picked up today.
Okay,
in jail.
thank you.
State of Ohio versus Ray W. Meredith, case number CRB 2038.
2038 is case number. Sir, you Ray W. Meredith?
Yes, sir.
Mr. Meredith, it's alleged you missed a review hearing in this court about a year ago. June 26 of 23 on a theft conviction.
Yes, sir. I think I was after that, has it been that long since I had come back?
That's what it says. It says you missed the hearing June 26th. Warrant actually got issued July 3rd, and today's the first entry since an arraignment on the warrant. So it's been almost a year. Time flies when you're having.
Well, I've had a lot of family problems, so, Mr. Chairman.
Do you admit or deny you missed your hearing?
I mean,
Do you have a good reason for not being here?
I've not been out of town.
Let me emphasize, do you have a good reason for not coming to court? Not a reason, do you have a good reason?
Oh, it's probably not, I mean, this has been laid on me over and I only got, what, 3 days of community service? Maybe
5.
5. My family was supposed to send my paperwork down here. I guess he hasn't sent the paperwork.
I haven't seen anything.
I seen the lows, I don't know, if I'm looking at it, I seen the fair asking about it. All I can do, Mr. Gabbard, is come and start working. I'm not hurting from my surgery no more. I got no excuse like that.
How'd you get picked up on the warrant?
I was going to Walmart, get my medicine.
Got pulled over on traffic? Did you get a ticket on that, or?
But yeah, but
When was that?
yesterday,
Okay, I'll send you the time served. You get double credit tomorrow.
where I got to look right here.
Right here, 7:30 a.m.
I'll be here in the morning.
There's a township cleanup day. We're giving double credit for people that come tomorrow for
One
community
day
service.
only.
Yeah, work 1 day, get 2 days credit. You can't beat that.
No.
Okay, I'll set your next hearing for June 3rd.
Okay.
I'm showing that you owe $50 for a warrant fee and 5 days community service. So get it done before June 3rd, you don't have to come back.
Okay. And what about the $50 though?
You gotta pay that.
That's the new load.
When you miss a hearing, all these people out here, they gotta type up a warrant, and they gotta get in the computer, they gotta tell the sheriff's gotta get in, type it up, and then it goes all over this. It's actually worth more than $50, but that's what we charge.
I believe it's 100 now.
Oh, it's 100? Well, in here it's 50.
The only reason I was asking to make sure that's the only reason that I owe is that all?
Well, it was assessed a year ago.
Okay.
It's 50. Yeah, that's all you have.
Okay,
$50.
thanks.
You're done.
Okay, thank you.
State of Ohio versus Brendan Rude, case number CRB 24254, A, B, and C. Rude.
Your Honor, I did a pre-screen with Mr. Rude, and if it's agreeable with the court, I'll accept him into treatment.
Guess you talked to OVP too.
Yeah, we don't accept the insurance that he has, so,
Okay, you don't accept.
yeah.
All right, sir, you're Brendan G. Rude.
Yes, sir.
Mr. Rude, I'm Judge Capper. This is your arraignment hearing. You have the right to remain silent. You don't have to say anything. If you do make statements, it's on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail make the state prove these charges beyond a reasonable doubt. You understand those things? You've got 3 charges. The first one, 24254A, alleges obstructing official business. That on May 1st in Rome Township, without the right to do so, you purposely prevented, obstructed, or delayed the performance by a public official of their authorized duties in their official capacity. That's a second-degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. The B case alleges disorderly conduct. It's alleged the same time and place you recklessly cause inconvenience, annoyance, alarm to others by engaging in fighting, threatening to do harm to other persons or their property, or being violent or turbulent. That's disorderly conduct. It's a 4th-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. And then they also charged a disorderly conduct minor misdemeanor variety, saying that you did not persist in that conduct. The jailable type is where you're persistent. So, do you understand the 3 charges? Do you have the money to hire a lawyer?
No, sir.
Well, let me ask you, I'll skip a step. How do you wish to plead? Do you have a job? Do you have no income? Okay. What?
I have a
Well, it'd probably be better if you don't.
I was out the house and I had a job lined up when I started. I had to sell the paperwork.
Well, the main thing for me is do you have any income now? You don't. All right, Mr. Steyer will be appointed to be your attorney. Entered a not guilty plea for him. He's expressed interest in going to, I'm assuming, inpatient treatment?
Yes, sir.
What's the state's position?
Well, we're not opposed to that. I don't know much about all the circumstances, about whether there needs to be electronic monitoring or something of that nature.
Just gauging from my pre-screen, I don't see the need for a monitor.
Okay.
And I would ask for an order, Your Honor, with the release that,
I'll set bond at $2,000 OR with a release to RRS for inpatient treatment. Not guilties are already been entered as his plea. Come back for the first hearing in 2 weeks, May 17th.
I'm additional on the docket that day, we make certain of that. I'm actually on the docket, so it's perfect.
May 17th will be the next hearing, 10 o'clock. Order him released to RRS only.
Thank you, Your Honor.
You're welcome. Okay, that's all. You come back and I'll get a report. Make it a good one, that I get a good report, you're doing what you're supposed to do.
State of Ohio versus Corey Easton, recall, case number CRB 24222,
Serious
and
charge.
CRB 24247.
Would have been under cannabis from the get-go.
I can ask for continuance.
Okay, well, I can do the form, but I don't have the continuance on it. It says for, I don't care.
Yeah, let's figure this thing out.
I spoke with my client and told me that she's not able to approach this application today. She's down there for support with it. I spoke to Mr. Hill about possibly no work on the assessment. She was previously had some medical treatment.
I'm familiar with her.
The ARDs.
Are you with Corey then?
Are you with Corey Easton?
You might have to pick the hammer now.
Are you with Corey?
No, I think she wants to speak to me about Mr. Brew.
Okay, on the other case.
I'll talk to you in just a moment. I've got to get the file.
She has no reason to go back to the treatment facility before she's alleged to be trespassing. That's not going to be an issue. But I would ask for more on the about assessment and the assessment, whether assessment report will be necessary.
Was she trying to get an assessment from hometown or what?
No, Fred was in there.
Oh,
She was wanting to visit her friend up in the house, and they said, no, you can't do that.
Okay. And she's in Proctorville.
Well, it says Proctorville, it also says Southwood, I'm not sure which.
Okay.
One says Proctorville, one with the same road number. Do you Southwood or Proctorville?
South.
You want to, on this end, but she's Southwood.
So, is transportation an issue? So Lawrence County recovered.
We did do an admitted assessment and all that, if that's possible.
Yeah. You want to talk with her now? There's going to be a mental health component to this. I think she's had treatment. So why don't we start the process today, and then we'll come back out.
And Your Honor, we're going to ask for a protection order on the case involving Jennifer Craig as the victim, so we'll ask for maybe they can go ahead and do this too while they're talking.
All right. They're asking for a protection order. Can you go over that with?
Yes, I will.
What about my daughter that I trust her? She just take it from me and everything.
Well, talk to Mr. Smith about that. I know nothing about the circumstances.
I'll let you know.
You can say something about Oh, hey, Corey?
Mr. Smith, can you go with her, please?
Yeah.
No, just go in the back.
State of Ohio versus Stephen Baldwin, case number CRA 24.
Hey, how you doing, sir? This is Judge D'Amico.
All right, you're Stephen Baldwin, correct? Sir, you're Stephen Baldwin?
Yes, sir, I am. Stephen Ray Baldwin, Jr., Social Security 368-825-496, on the record. Yes, sir.
Does your father work at the, what do they call it, the county court office?
Well, my father used to. You talk about Austin
Ray Baldwin.
Ray Baldwin, yeah.
Okay, here's a copy of the charges.
Hey, I'd like to tell you something, Captain. Those charges, I never really did the crime or something, but I think I was really in a great state of mind at the time, and like only kind of gave me respect to the cigarette, and then they kept it. It's like it's on. They did inventory, but the inventory was clear on it. And there was nothing missing in the inventory. But I was trying to say, I wouldn't mind having, if you wouldn't mind, maybe like a OR bond or something.
Well, let me lead you through this. So let me first tell you what your rights are, which you may already know, that you have a right to remain silent, which is not one you've been exercising. You have a right to have an attorney and to have one appointed if you can't afford one. You have a right to bail and to make the state prove this charge, and it's a serious charge, very serious charge they filed against you. It may not be true, but you need to understand what they're alleging. It's aggravated robbery. That's a felony of the first degree.
There was an aggravation to it because it was only Branson and
Well,
weapon.
just wait till I.
Branson and weapon, and aggravation at all.
Mr. Baldwin, be quiet. The maximum penalty for this is 10 years in jail and a $20,000 fine. And it's alleged that on May 1st, 2024, while attempting to commit a theft offense, and while fleeing immediately after, you had a deadly weapon on your person and displayed it and brandished it, indicated you were possessing it and could use it. So that's why it's a felony of the first degree.
Oh, it's aggravated, yeah, that's what I'm saying, is that right?
Okay, do you have a job at all?
I'm on Social Security for mental illness, I have mental, I'm getting, I have a schizophrenia.
Okay. All right, Mr. Steyer, I'm going to appoint you.
I'd like to cut the minute so I can be on the, like, a drug thing, if all possible.
Well, I'm going to consider everything. I think what we need to do first is get the state's position on bond, then let your lawyer talk to you, then we'll come back and decide how we're going to handle the bond. What's the state's position on bond?
The state would request a $50,000 cash assurance.
Okay, so that's what's requested. Mr. Steyer, I'll let you speak with Mr. Baldwin when you're ready to discuss bond. We'll recall.
State of Ohio versus Danielle Ham, case number CRA 24229.
Your Honor, we're going to take testimony on this, I believe, so I don't know if there's anything else pending or you want to do that now, but I need to also need to speak to those individuals up there.
Okay, we'll take it at the end of the docket. There's going to be evidence on it. Okay, we'll come back to your case because we're going to be witnesses testifying.
State of Ohio versus Jason A. Tolliver, case number CRA 24250, TRC 24880, here at the court. Mr. Tolliver. Mr. Tolliver.
All right, sir, are you Jason Andrew Tolliver?
Yes, sir.
I'll try to speak up because it appears you're hard of hearing. Mr. Tolliver, did you hear me explain the rights of defendants? I've done it several times today.
I heard what I could. I tried to hear most of it. Some of it I couldn't hear.
I'll go over it again. You have a right to remain silent. Do you understand that? You don't have to say anything.
Yes, sir.
You have a right to have an attorney. You have a right to have an attorney appointed to represent you if you can't afford an attorney. You have a right to bail. You have a right to make the state prove the charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Okay. The most serious charge is 24250, improper handling of a firearm in a motor vehicle. It says that on April the 30th of this year, in Perry Township, you had a loaded handgun in a motor vehicle in your possession while you were under the influence of alcohol or drugs. So that's a felony of the 5th degree. Maximum penalty, 1 year in jail, $2,500 fine. The second charge is case number 24880, alleges that at 5:35 p.m. in the village of South Point, you were operating a motor vehicle while you were under the influence of alcohol, and that you took a breath test and tested 16 on a breath test. So what does that mean? there's a per se level under Ohio law of 8. So if you test 8 or higher on a breath test, there can be a presumption that you're impaired if the state can show compliance with the rules for giving the test. So that's important. So they're saying you're 16, that's more than 8. There could be a presumption of impairment if they can show they comply with the rules they have to follow for giving the test. On that charge, the maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most that can happen. There is a minimum. So the least that can happen if you're found guilty is 3 days in a treatment program, a $375 fine, and a 6-month license suspension is the minimum. You understand that charge?
Yes.
Do you have any questions about these charges?
No, sir.
Do you have the money to hire a lawyer?
Yes, sir. I talked to Mr. Chris DeLauder.
Okay. I'll put him down. You're going to hire him as your attorney?
Yes, sir.
You have a right to have a hearing within 10 days because of the felony. 15 days if you're out of custody, which you will be. When do you want to come back for your next hearing? Did you talk to Mr. DeLauder about when he's available to come back?
I just talked to him over the phone, and he told me to get a hold of him after today, after I get out of here this morning.
Let's set it for the 17th. That's within 15 days.
17th?
I'm set it for May 17th for a preliminary hearing and pretrial. Did you post any kind of bond?
No, sir.
Okay, I'll let you sign a signature bond since you showed up on your own. You're going to sign your own bond, and I'll make it an amount of $5,000. But as long as you come to court, as you're ordered to, you don't have to post the $5,000. You'll have to post it.
Yeah, I'll be here, sir.
After you, if you don't show up, then you owe $5,000 and you get a warrant.
Okay.
So just show up, you don't have to post any money.
Okay, so sign right there.
May I approach?
Yes.
This guy here hasn't signed. I've got to sign it, I'm just there. All right.
Oh, do you mind?
All right, any questions, Mr. Tolliver?
No, sir.
Be back here May 17th. Call Mr. DeLauder, unless he tells you a different date, that he's made arrangements for a different date.
Okay.
Come when he tells you.
And I'm done for the day?
You're done for the day. Yes, sir.
Okay, thank you, sir.
You're welcome.
State of Ohio versus Christopher Davis, case number TRC 24885, A and B.
Sir, you're Christopher Davis?
Yes.
And you've got criminal charge and an OBI. Have you been here when I explained defendant's rights?
Yes.
You understand those?
Yes.
The criminal charge, 24-253 case number, alleges April the 10th in Rome Township, you, while being under the influence of alcohol or drugs, were using or carrying a firearm. That's using a weapon while intoxicated is a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Then it's also alleged that at the same time and place in the village of Athalia, that you were operating a vehicle while you were under the influence of alcohol or drugs. And they charge you under the village ordinance, which is a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine, 3-year license suspension. And they're alleging you refuse to take tests. State of Ohio is also alleging you had a plate light out on the vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand these charges?
Yes.
You understand the rights you have?
Yes.
How do you plead?
Not guilty.
Do you wish a lawyer appointed to represent you?
I need a court-appointed lawyer.
Are you working?
No, not at the moment.
You have no income?
No, not at the moment. Only do little side jobs.
Mr. Warford, I'll appoint you. The plea is entered. He can sign a $1,500 signature bond.
Thank you.
May 20th or 31st?
I believe either date's good.
Let's do the 31st. May 31st, pre-trial at 10 a.m.
Thank you, Judge.
It's not, but it's close. May 31st.
Thank you.
You're welcome.
It's okay if it's not, if you don't file it, it's okay. No, don't file it.
State of Ohio versus Alpha Donnelly on recall, case number CRB 2457. Case number State of Ohio versus Rachel Harvey, case number CRB 2458. And State of Ohio versus Caitlin Leftwich, case number CRB 2456.
I need Mr. Morford and Mr. Stein also.
Caitlin is a victim of Alpha. She's also a defendant with Alpha. She's also a victim.
Mr. Stein may be in the back.
Caitlin is from dismissal. Rachel, she wants her case dismissed.
Come out.
This is one dismissal. Sure. So we have all three defense attorneys here. Well, Clinton was here, so I don't know why they're meeting back.
Yeah, go get him.
Yeah.
So I had to pull.
I know that. Yeah. I've tried. I felt she's here. I've been talking to the other person. Probably not going to happen.
Okay. So Mr. Donnelly, we were checking to see if the other parties were were agreeable to his being dropped?
Well, there are 3 individuals altogether involved in one way or another. And I believe all 3 of the attorneys are here, and we've contacted the other 2, both defendants and victims, and they all are in agreement to a dismissal. So I think that, given all things considered, maybe this is best to go ahead and do this. We would, I don't know if this complicates anything or not, but generally, we're going to ask for at least 1 court cost.
Well, my notes were that Rachel Harvey was going to pay costs.
I believe my client, Ms. Harvey, was going to pay the cost. We weren't scheduled till the 10th. I don't know if they've been paid yet or not.
Let me see something.
They have, actually. Well, 125 has been paid.
Well, I think that was the court cost at the time this was filed, so.
Okay, we'll dismiss it. All these cases are dismissed.
Thank you,
If I may say something.
May I walk back through here?
Yes.
All right.
Yeah, if I may say something, well, I get papers saying it's dismissed today, so I can turn to my employer so I can go back to work. I've been without work for...
Mr. Northrup can help you with that. There will be a judgment in your
Thank you, Judge. Good.
State of Ohio versus Kimberly D. Trout, case number CRB 24252.
All right, this is for arraignment. And you're Kimberly Dawn Trout?
Yeah.
Ms. Trout, it's alleged that at Fayette Township on May 2nd, you tried to defraud Walmart property without their consent. It's a theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yeah, I plead not guilty.
Do you wish to have a court-appointed lawyer?
Yes.
Do you have a job?
No.
Do you have no income?
I get SSI.
I'll appoint Mr. Scott to represent you. Not guilty plea is entered. I think he said the 7th, was it the 17th?
It's the 17th, Judge.
May 17th will be the next hearing for pretrial, 10 o'clock. She has a bond up with Mr. Sowers. So it's continued. Not guilty plea is entered.
State of Ohio versus Leah R. McDowell, case number CRB 24251. Leah R. McDowell.
You're Leah R. McDowell?
Yes.
Ms. McDowell, it's alleged that at Fayette Township, May 2nd this year, you tried to defraud Walmart property without their consent. Maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
You understand your rights?
Yes.
Do you have any questions about your rights?
No.
How do you plead to this charge?
Not guilty.
You want a lawyer appointed?
No, I'll get one.
Okay. How much time do you need to do that?
Probably a few weeks.
Let's make it May 28th. Your next hearing will be May 28th for a pretrial. Your bonds continued. Not guilty plea is entered. Any questions, ma'am?
May 28th at what time?
10 a.m.
Thank you.
You're welcome. Free to go. Okay, yeah.
State of Ohio versus Cody Hatton, case number TRC 24538, A and B.
Okay, I have a judgment entry from Mr. Holt asking for a continuance, which I am approving. Case is continued to May 13th at the defendant's request. I approve the entry. Sending Mr. Holt a copy of the entry.
State of Ohio versus Crystal McMillan, case number TRD 24646, CRB 16688.
All right, this is set for trial today. It is afternoon. Crystal McMillan is here. So I have, the state asked for a continuance, saying the officer can't be here, but does not give me a reason why the officer can't be here. You want to say anything else about it, Mr. Lee?
Well, Your Honor, if it pleases the court, this case kind of snuck up on us. I see in the court's docket that it was originally before the court on April 1st, and then there's two notations. One of them is set for bond forfeiture on 4/29, and then set for trial on 5/3. I don't know exactly how that all transpired, but it simply did not get on our radar until earlier this week, when I was looking to see what was coming up. Back in the middle of April, about April 15th, Trooper Beam gave us notice of a few dates going forward for this next month or two when he would not be available. He gave us that information before I became aware that this trial was actually happening. And so I did not ask him what his actual reason would be for not being available, but I kind of give him credibility because I think he's very professional. I don't think it was a picnic he's going to. So I didn't subpoena him, knowing he wasn't going to be available.
Okay, I'm going to dismiss it then. That's inadequate reason. There's no reason given. And it actually was set on April 1st, because she came in late that day. My notes was she came in late. I set the trial date then, so it was over a month out.
So the,
Now wait, you don't need to say anything. That case is dismissed, but you've still got other problems. 16,688, and your bond is on that now, because you had a theft conviction. You didn't finish the community service, and you didn't show up for a hearing, so you have to finish that now. You've got 54 hours of community service and a $50 warrant fee to pay. So what I'm going to do is I'll just put you back on the review hearing docket. You got to work off this community service, and you got to pay your $50 warrant fee. But 24,646 is dismissed, the new case. Your next review hearing is going to be June 3rd at 9 a.m.
so will that, at the BMV, will that just,
It'll be wiped out. The new case, yeah, it's dismissed. Now, it doesn't, they're alleging you didn't have a driver's license, so it doesn't fix your driver's license. It doesn't mean now you've got a driver's license all of a sudden. It just means I'm not going to let them go forward with it or ask for a continuance. I'm not going to give them a continuance. So you were here, you're ready to go. They had adequate notice, so I'm not continuing it. But you still have this whole case you got to take care of.
I will.
You understand?
Yes.
June 3rd, 9 a.m. is your next hearing. Once you get this done, you don't have to come back. And if you're driving, you need to get with the BMV and get your license reinstated.
I'm going to.
Okay? Do you have any questions?
Thank you.
You're welcome.
State of Ohio versus Sherry Fraley, Warrants County Jail prisoner, case number CRB 21255.
Ma'am, are you Sherry Fraley?
Yes, sir.
Ms. Fraley, I'm Judge Capper. I'm going to go over your rights with you. You may already know them, but let's make sure. You have a right to remain silent. You don't have to say anything. If you do make statements, it's on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove his charge beyond a reasonable doubt. In fact, well,
That's not a serious charge, is it, sir?
it was initially the affidavit. It looks like it's filled out as a minor misdemeanor disorderly, but the complaint alleges a 4th degree.
And that is because the offense occurred in the presence of an officer, and she did not desist after being warned to desist. So we felt it appropriate to charges it in before.
Okay. Ms. Fraley is alleging that at Fayette Township on April 30th of 2024, you recklessly caused inconvenience, annoyance, alarm to others by engaging in fighting, threatening harm to other persons or property, being violent or turbulent, and was committed in the presence of a law enforcement officer and persisted after you were warned to stop. So that's a 4th degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand the charge?
Yes, I understand the charge.
And you do understand your rights you have?
Yeah, we know.
You want a lawyer appointed?
Yes.
Do you have a job?
No, not currently.
You have no income? Is Mr. Stratton still here, or do you leave?
I'm not saying.
Is there any way that I can get involved?
Yeah, there is. Mr. Smith, I'll appoint you.
Thank you.
So we'll need to come back pretty quick unless there's a time waiver on this one, because it's a 4th degree misdemeanor.
This is not going to work.
Right, but Judge, she's been a war officer, that's given time.
Okay.
And so what we just got on the criminal history, here, but I will pursue that.
State, any objections or no work?
What we'd like to do is read a short statement to you
Okay.
about the circumstances. April 30th, 2024, Lawrence County Sheriff's Office received several calls in response to a female later identified as Sherry Fraley walking in the middle of the exit ramp of the 17th Street Bridge, screaming and waving her arms around. Detective Newman and Deputy Frame made contact with Sherry, who was talking to someone named Richard that she stated was standing behind her. Detective Newman attempted to get Sherry to go with EMS to make sure she was not a harm to herself. Sherry refused. Detective Newman then placed her under arrest for disorderly conduct. Raises some concerns.
Yeah, why don't we, I would like to have her get an evaluation. She lives in Ironton.
Currently homeless, I've been with the shelter since 2019, in the first area.
Where are you from originally? You're from Ironton originally? How long? Well, why don't we do this? Once you talk to her,
Yes, no problem.
if there's any indication of substance use, we could probably find her a place where she could go in, have a bed and treatment and food, place to go. Why don't you take the file, talk with her, and we'll try to figure that out later. Yes.
State of Ohio recalls Eddie Easted, case number CRB 23203, TRC 21269, TRC 17442, A, B, and C. Eddie Easted.
Mr. Morford.
Judge, with respect to the failure to hear Mr. Eastep, going through his changes in his rights last April, he decided that he needed to get out on account of two reasons. Number one, he believes that the law enforcement has been harassing him. And number two, he decided to get away from drugs. He meant that it was expected. It was time to get his life straightened out. He had many things going on.
Where would he spend the night if he was released from jail? Where are you living?
Well, right now, I'm staying with my mom, helping her right now.
Where she live?
She lives in Southland, that's why I came back to July. I had to help me.
Well, I think he's gonna have to have a bond. He's got 2 old OVIs he's never finished, and a new case that's never even been pled out or tried, so. I'll set bond. Can you post any kind of bond? Well, I can't trust you to come back to court, so you're gonna have to have a bond. $1,500 cash for surety. Let's set it. Let's set it for next Friday, May 10th, for pretrials.
The old OVIs, they've already been
Yeah, he's been, let me make sure. Yeah, 21-269 sentence, got 60 hours of community service, $765, fine, ordered to treatment. There was some payments on his fine, but it's not completed. 17-442, he did pay all his fine on that, never did his community service, it's alleged. And he didn't go to the 3-day school like he was required to. And no proof of treatment on the second offense. So May the 10th will be his next hearing, 10 o'clock.
Judge, we need that iron out of his community service. He believes that he has completed community service.
Your Honor, he done, I do know that he did do some, but he was not completed.
Okay. I think the record shows he did some.
Yes, it does. But not completed.
Right.
Okay.
State of Ohio versus Kyle W. Hopkins, case number CRA 24245.
It's Mr. Morford's case on a Rule 4, Meigs County. Okay. Just wait.
Thank you, Judge.
right, Mr. Hopkins, you signed a waiver of Rule 4 hearing. What that means is you are agreeing that you are the Kyle Hopkins that Meigs County wants, that they have a warrant for, and you agree to go there. That's what you want to do. Now, I'm going to set bond at $1,500 cash or surety, but it's my understanding you don't think you can post bond?
It might take just a day or two, sir.
Well, I can give you some time, but here's the way that works. If I give you time to post bond, I'm also not going to tell Meigs County to come and get you, because I'm not going to have them drive down here to get you and then you post bond and you're out running around and not at the jail. So if you want some time to try to post bond, I'll give it to you. But I'm not going to count that time against Meigs County. Then in the event that you can't post bond, we'll kind of start the clock over again once I find out whether you can or can't. So what I would propose, if you want a chance to try to post bond, I'll just continue the case till Monday, give you the weekend to try to post bond. And then if you post bond, I'm going to order you turn yourself in Meigs County within a week, or come back here for a hearing within a week. If you can't post bond, then I'll order the Meigs County to come down here and get you. Okay?
I'll get it to them regardless, but,
Well, you know what? People have lied to me before, so I can't take your word. Everybody says whatever, in my experience, everybody says what they can to get out of jail. If it's, oh, judge, I'll show up, they're going to say that. So, and then a lot of people don't show up. So that's why I got to have bail is security that you will show up. So do you want the weekend to try to post bond? You can add to, yeah, I can give you whatever time, but then I'm going to start, if you can't post it by the 8th or whenever you think you can get the money, then I'm going to start the clock on Meigs County to come get you out, and it'll probably be a week from then before they make them come pick you up. So you could wind up sitting in jail longer if you can't post bond.
I know Forest Shores the 8th, I was able to post bond Forest, and then be able to pay bonds or whatever on that same day.
Are you here the 10th, Mr. Morford? I'll set bond at $1,500 cash or surety. I'll order you to turn yourself in by May the 10th. So I'm not going to know if you post bond again until May the 10th. So I'm going to put you back on our docket May the 10th. If you're still in the jail, then I'll start the clock on Meigs County then. Say, okay, you got a week to come get him because he couldn't post bond.
What time on the 8th is the latest that it can be?
I'm giving you till May the 10th to post them.
Post bond?
Yeah.
Oh, okay.
Because I'm going to have you back here. If you're still in the jail, I'm going to see you on May the 10th. If you're gone, then you got to go turn yourself in Meigs County by then. That gives you 2 days to get up there.
I was just wondering about that. I know there's a certain time limits on being able to post bond on certain days or whatever that is. That's why I was wondering what time on the 8th. But you can be able to tell. Yeah, well, if he's giving.
I'm giving him-
the 10th, then I'll be able to do.
I'm giving him by 9 a.m. on May the 10th to post bond. And if you don't, and you'll still be in the jail, so I'll see you on May the 10th sometime that day, and we'll decide how we're going to go forward. I'll order Meigs County to come get you, and I'll give them a time frame in which they have to do it. So I'm going to order you turn yourself in if you post bond by May the 10th. So we can call up there and verify that you've appeared.
What time am I going to be?
You got until Friday. The 8th is on Wednesday, so
Yes, sir, I understand that.
you get your money on Wednesday, post it, then you got to get up there by Friday, Friday morning.
Is it $1,500, the whole $1,500?
Well, if you've got $1,500,
Well,
laying around that you want to post, you can post that with the clerk, and as long as you show up in Meigs County when you're supposed to, you'll get the whole $1,500 back.
Yeah, I understand all that.
But if you don't have $1,500 laying around, you want to hire a bail bondsman, usually that's going to be 10%, you pay them 10%, but you lose it. Then if you don't show up, the bail bondsman's got to pay the court $1,500, and they don't like that. They don't like it at all. So they're going to come and get you, put you in their vehicle and take you either to Meigs County or here to the jail because you didn't show up. That's the way that works.
Yeah, that is just usually whenever I've had bonds, or it's been set at like 1,500, 10%, or whatever, and I ain't never.
Well, that's what you pay the bail bondsman, but we don't accept 10%. If you're gonna pay us, it's gotta be the whole $1,500, because I would send Mr. James out to get you, but he doesn't like to do that, so he balks at that, so we'll let Mr. Sowers do it.
It's just, he was going to call the broker and let her know what was going on, so I was just wanting to know exactly
Mr. Cooper will let the bail bondsman know you want to talk to him. And if you're still in the jail, I'll see you next week. Hopefully you won't be. Hopefully you'll be in Meigs County. The only courthouse in Ohio where you can walk into the ground floor off of 3 different levels. Okay. Who would want to talk to Ms. Finley? Fraley, I'm sorry, Fraley, that was in the middle of the 17th Street Bridge exit, has mental health issues. I don't. Okay. Bethesda. He's in the back.
State of Ohio versus Corey Easton, case number CRB 24222 and CRB 24247.
Judge, apparently she does qualify for treatment. They can get her inpatient
We can get her today.
and you can do it today, apparently.
And then we'll,
Is she agreeable to that?
She is.
Okay.
We talked about that. You want to do that, right? Like we talked about. You want to do the treatment, get out of jail, go to treatment today like we talked about?
For all of them, you're outpatient.
Well, you don't get to bed, like we talked. Stay in the jail or you can do the
Can I go to
inpatient.
MVP?
We don't have any beds available.
They've got a bed today, you got to jail today.
Is there smoking, like cigarettes or anything?
we do allow smoking, like cigarettes and vapes or whatever,
One of my
yeah.
favorite this conversation, I thought we were all on board. But you can go today and they'll work out the cigarette issue. Do you want us to leave that?
Yeah.
Okay.
Okay, I'll order her release to Lawrence County Recovery.
Hometown recovery.
I'm sorry, Hometown Recovery. I get confused.
No, you're okay.
And set her bond at $2,000 OR. And I think we probably should come back pretty quick.
I'm here, I'm not next week, I'm here 17th.
Okay, May 17 will be the next hearing. Okay, we enter an order she be released to Hometown Recovery today.
Thank you, Your Honor.
State of Ohio versus Marissa L. Short, here at court, case number CRA 22623, CRB 22624, PRC 222494, A and B.
And this is Mr. Morford's case.
Mr. Morford?
I didn't see him out there. Is he in the back?
I think he's
Here you go. This is a case that had been sent to QRT.
Yes, Your Honor. She's been unsuccessfully terminated from QRT.
Where's it? So I don't know if you were aware of that, Mr. Morford, this something that just happened recently.
I'm not aware of it, Judge.
And I think she still has an ODI that she hasn't been, I don't know if that, she was sentenced on that. I have to review the file. Do you want to talk with her then, we'll recall it?
Yes, please.
And I don't believe she has been sentenced on that, Your Honor.
I don't think so either. Case will be recalled later.
Where were you?
State of Ohio versus Haley Early, case number CRB 2480.
All right, Ms. Early is waiting patiently at Counseling Center for her hearing. And Ms. Early, how are things going at the Counseling Center? Okay, any problems?
No, we did find out that my kids can't cross the state line, and they won't be coming over here.
Well, I'm not giving up on that, because we've got another case where they initially took that position, but they changed, I think they may change their mind if they see you do well. That's
All right,
what
I just got to do, so.
And let me ask you this, the case involving West Virginia Children's Services, is that before a judge in Cabell County?
Yeah, I'll see Ferguson for my things too.
Judge Ferguson, okay. Do you have a lawyer representing you in that?
Paula Herbert.
Herbert?
Paul Harbor.
Paula Harbor, okay. Actually, believe it or not, I know her too.
Okay, she's on 6th Avenue, yes.
Okay. She has Ohio roots. So what I'm going to suggest is we need to get some of this information to Ms. Harbor. You know when your next hearing is in Cabell County? Because you know what? It's not up to Children's Services. It's up to Judge Ferguson. And sometimes I've been known to sneak in his back door over there while he's playing hearts at lunch.
I'm pretty sure it's like June 11th, but I can have her text somebody with the information for sure.
Okay. I've got a report. Is everything okay from?
Everything's good. She's
Okay.
adjusting well.
Okay, I think after a few fits and starts, we're on the right track. So I don't want you to get discouraged about your kids because just because West Virginia Children's Services says they can't come to be with you, that doesn't mean that the judge is going to agree with them.
Right.
So what you need to do is do what you're doing, get clean, you know, because I would think the judge would want to see you and your kids reunited. And if you're doing really well, I kind of feel like he's going to be on board with that.
Right.
Okay?
Thank you.
So we'll keep working on this. I will contact Ms. Harbor, let her know what's going on from here. Does she have any idea where you are now?
Yeah, I was at court last week, so they all know.
Okay. All right. We'll get some information to her, and then you get clean and get in recovery, and that's the best thing you can possibly do for any case you've got, whether it involves your kids or anything else. So.
All right.
Okay, you look good. Keep working. Let's set another hearing for you. Let's see. Let's make it May 20th. That's a little more than 2 weeks.
Okay.
and it'll be on the docket as the sentencing at 10 o'clock, and you can appear just like you are now, as long as you're doing what you're supposed to, doing by 12 rounds. Okay, good job, keep it up.
Haley, remain, this is much more for justice than when they represent you. I tried to notice, I figured you were in jail, but when you weren't in jail, and they were at TCC. But you have a lot of people pulling for you. And I know Judge Capper, he's contacted me personally about your issues. He's very concerned about you, Mom, and the 3 children you've got. You have 3, don't you?
Yes.
You and those 3 children are Judge Capper's focus. He wants you to be united as a family. And if you listen to what he said, if you comply with the programs, he might be persuaded to go talk to Judge Ferguson and interrupt his heart schedule and say, hey, let Miss Early see her kids. So keep that, that's something you're working for. If you show Judge Capper you look for his effort, he will help you. He will help you see your children. But you gotta get clean. Okay? And my phone is always open. If you need me, call me. And I'll get the information to your, are you at TCC in Ironton? Fortune. Okay. Just do what you need to do, and please, think about those 3 kids you've got 24/7. Okay?
Thank you.
All right, once you see Mr. Culver, right?
Tarvin.
Tarvin.
Close enough.
Ryan, at least I got the first name now, it took me a while. Mr. Morford, why don't you talk with him, because he's the liaison, he can help you connect with Haley.
Thank you, Judge.
You're welcome.
State of Ohio versus Misty D. Dotson, case number TRC 23706, AB considered.
Mr. Scott's case set for sentencing.
That's correct, Judge. This is an ODI case we pled guilty to. Ms. Dotson went and completed inpatient. You're outpatient.
Yes.
And she's now outpatient. I have an assessment dated April 30th from Marshall Health, where she was diagnosed with opioid disorder severe, where they enrolled her in weekly counseling, medication treatment that she is current on. She is
Yes, at
attending.
ProAct in Huntington.
Yep. I also have a drug test dated April 26th that is negative minus prescribed medications. I believe you're on Suboxone, correct?
Yes.
And she has prescribed Suboxone.
Okay, so we're going to go ahead and do sentencing today.
I'm fine with that if the court's acceptable and the state.
Mr. Deal?
Your Honor, it's a first offense. It's marked as a refusal. We're not opposed to the court imposing the mandatory minimums, and if the court feels that her treatment efforts are sufficient, then we would agree to waive the DIP program in lieu of her completion of treatment.
Okay.
And that's what we would ask for, Judge.
I'm going to do that on this one. One thing, maybe, I don't know, we need to discuss it on the record, but I'll put it out there so lawyers can hear it too. We're going to have a new driver intervention program just starting in June. So to support them, and not that we're going to require people to go to that, or not, I have no interest in it, but I just want to see them be able to be successful. Probably not going to be waiving the DIP scores often in the future so that they'll have some clientele. I want them to be successful. I think we need that here in the county. We haven't had one for a while. But in this case, I'll agree to do that. Anything you want to tell me, Ms. Dotson, before I finish your sentencing?
No, Your Honor. But I did graduate OVP on the 12th. Went home on the 15th. I'm glad to be home.
Okay.
Judge, I will speak on her behalf. I picked her up about a month and a half ago. She's been very compliant. She didn't waste this court's time, didn't waste my time, the state's time in fighting a charge that she knew she committed. She pled guilty pretty immediately. She asked to go to treatment. She took it by the horns and completed.
Congratulations on that.
Thank you.
Keep working. It's not over. I mean, your fight is not over. You got to keep working at it. Okay, the minimum fine I'm allowed to give you is $375, so I'll do that. It's $375 fine. Court costs, I'll give you a 6-month license suspension, so that's already up, actually. I'm going to give you 30 days in jail, suspend all of it on the condition that you do 5 days community service here. I'm going to suspend the driver intervention program. You don't have to do it, but I do want you to continue in aftercare as part of your probation. So continue with your outpatient treatment. And I'll set a review hearing for you. She'll have level 4 probation. Her first review hearing will be June 24th at 9 a.m. So you got to come back and I want to check up on you. And I need a report then as to how you're doing. Now, did you say, are you going for PROACT or OVP?
PROACT.
PROACT, okay.
Dr. Hanson.
Yeah, good man.
Yes.
Get me a report. I really like their program, but sometimes they're hard to get reports from, so.
That's the reason why. Yes. What time did you say it was? At 9 o'clock?
9 a.m. June 24th.
Make sure you're at 9 for those.
All right.
And then she had a driving under suspension. I'll impose a $50 fine on that. And then there was the C case, failure to control. Was anybody's vehicle damaged?
No.
Okay.
No.
All right, $25 fine on that.
Now, do you want my drug screen and my report from my counselor and from the?
Yes. Put that in your file. This is from PROACT?
Yes.
Okay, very good.
Thank you.
Yeah, this is what I need every time you come back, something like this.
Yes, Your Honor.
Thank you.
Thank you, Scott.
Thank you, Judge.
You're welcome.
State of Ohio versus Travis L. Salyers, case number CRA 22-415, CRB 22-420.
This is review hearing today. Mr. Salyers is here. He's at OVP.
Yes, he's at OVP Health in Huntington, and he is compliant with treatment at this time.
Okay. I'll cancel the warrant because you got called earlier. You weren't here then.
Yeah, I apologize about that, Your Honor.
And you've got community service and fines to still pay.
Yes, I'm going to pay $50 today whenever I go to leave.
And you can get double credit if you come out for community service tomorrow.
What is it?
You can get double. You get 2 days credit for working 1 day of community service tomorrow because it's a cleanup day.
Okay.
You come here at 7:30.
All right.
Next hearing, June 3rd, 9 a.m. See the clerk to make the payment.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Stephen Baldwin, case number CRA 24.
It's Mr. Steyer's case.
Your Honor, Mr. Healy here for this, So, I've tried the local providers, find somebody who might be able to take Mr. Baldwin, please help. I've not had any luck with that. We do have, did you hear from ARC or have you not heard? We're looking at the possibility of ARC in
Their new facility.
Bellefonte. We haven't heard anything back from them yet. So at this point, I don't have anywhere he can go on a bond other than what's been set. I don't believe there's a cash or surety bond he could make that the state would find sufficient if he were to not be placed somewhere. So
I'll come back Monday to see if.
Point, yeah, I think we're going to just keep this on a short. Get him back here Monday and try to do do some more, maybe we can get an answer by then. It's also, I've discussed this with Mr.
Legal license. I'm sure we had as well. We just say that big was stated in this court.
All right, Mr. Baldwin, I believe is probably not competent to assist in his defense. It's my intention to file as well as you guys are competency.
Okay. Well, all right, let's just put it back on the docket for May the 6th, and then that's Monday, and then we'll deal with the other issues that may need to go to common pleas.
Today's the 3rd.
May the 6th.
That's Monday, as quick as I can get it, sir.
Okay, all right, well, I would hope that someone that they care so much about drug addicts and those treatment facilities, I have empty bed, I'll check and see, would take me in, does I need the license in the body while I say it, they will.
May the 6th.
Your Honor,
Thank you.
we'll try to have the officers here on Monday, and maybe we can do a preliminary hearing on Monday.
Get it to the common pleas.
I'm going to object to that.
I know, we'll have to. I don't know if that's true or not. I understand your argument.
State of Ohio recalls Marissa Short, case number CRA 22623, CRB 22624, TRC case.
It's Mr. Morford's case.
May I approach, Your Honor?
Yes. Okay. All right, how's the state want to proceed?
Well, it's my understanding, well, not just my understanding, I've got a letter here from the QRT program that she's been discharged from that. They feel that she's not being forthcoming, she's not being honest about things. The Bethesda report looks like she's had some issues as well. So, she's pled guilty to the OVI, and we agreed to delay sentencing for the purpose of allowing her to be successful in treatment. And I don't think that at this point in time that we can say that she's being successful in treatment. In fact, it sounds like it's the opposite. I guess one thing going for her at this point is that she had a recent negative drug screen. But I guess the two options that we would propose is, number one, we would take the possession case to the grand jury and then ask that she be sentenced on the OVI today. An alternative would be that if she's sentenced to jail in the OVI today, and that she would do some jail time and see if that helps her gain a new appreciation of what she needs to do before this court in this drug charge, that maybe we could be convinced to leave the case here. But we would want a jail sentence imposed on the OVI today substantial enough that if she continues her noncompliance, then she will receive an adequate punishment.
Excuse me, Your Honor, what is it TRC 222494, the OVI we're talking about?
Yes.
It's already, she's already been
Okay.
on March the 3rd.
How much time did she get, if you can see?
20 days suspended.
Yeah, I have a note here that she was sentenced.
Well, I guess on first blush, my thinking is if someone goes to QRT and is unsuccessful, for there to be consequences, it needs to go on to your injury. Because otherwise, why would we do it?
It makes perfect sense.
So she's already been sentenced on the OVI. What was set for a review hearing today, actually. Has she done anything toward her? She's got community service and other requirements.
Have you done community? You said that she did community service a long time ago.
Okay, she has done some community service, looks like.
She did it through Ironton Municipal Court.
Yeah, it's in the record. Okay, so the state's gonna, you want to just nolly the 22-623 to the grand jury?
That would be my thought. I want to make sure, though, that, I mean, she would still, apparently still at Bethesda.
She's still at Bethesda, and she was ordered to complete treatment there as part of her sentence on the ODI.
And so we could go ahead and nolly the felony charge for the grand jury.
All right, 22-623 will be nollied to the grand jury. She is to continue with treatment at Bethesda under the ODI sentence that she got in March. And I'll set her next review hearing on it for June 3rd. So that'll be at 9 a.m. It'll be a review hearing, June 3rd.
What about, 22 or 624?
That should go to the grand jury also.
Which one's that?
There was a drug paraphernalia misdemeanor, that'll be nollied to the grand jury also. It'll go with the possession.
Thank you, Your Honor.
Okay, June 3rd is our next hearing here. And then we'll be getting contacted, she'll get something from Common Police Court if there's an indictment returned.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Sherry Fraley from Lawrence County Jail, case number CRB 24255. Sherry Fraley.
We got the real good.
I was involved with the Cardinal, and I wanted everybody.
You can hear what she said. She said she does not want to go to treatment, so we're going to issue a bond.
I was in Ross County, down here in Cardinal. I didn't go place with,
I'll set bond at 1,000 cash or surety.
I'm not back till 17.
May, set the next hearing May 17th.
This is an M4. So we have a limited amount of time to try the case. I guess we have 60 days to try an M4.
She just get ready today, over 2 weeks. If we don't get it resolved, 17 weeks at a trial date.
Pre-trial May 17th.
Thank you, Your Honor.
Yes, thank you, Judge.
Your Honor, I need her to sign it.
What? No, she's not, it's not her work.
That's cash or surety.
Cash or surety.
State of Ohio versus Brittany Eplin, case number CRB 23589.
Yes.
Let me see, maybe what, I think that was a witness. Let me see. Oh, okay, this is All right, this was put on the docket today due to some problems at treatment. She's allegedly not being compliant. Testifies that for fentanyl after a pass has been confirmed by outside lab. Have you had a chance to talk with her, Mr. Walker?
Yeah.
Anything you want to relate to the court?
We had too much being counsel.
She's going to change her attitude?
Yes, sir, I need to change my attitude.
Do what you're told when you're told?
Yes, sir.
How you're told?
Yes, sir. I would just need another please give me another.
Is Bethesda willing to continue to work with her?
We're not willing to want to move forward with Ms. Eplin. We've tried for 6 months and she has not progressed, or her behaviors have they've been outlandish, and we've tried. She has one of the best counselors at our facility, and we have tried, Your Honor.
Okay, do we have another agency that's got a female bed?
I think Hometown was willing to talk with her, Your Honor.
Okay, let's let you do an assessment and then we'll come back after that happens.
Okay.
Has she seen the documents?
I'll show her.
Okay, thank you. Okay, we'll come back. I'll let you talk to a representative from Hometown, and we'll come back after that happens. I know we're going to
State of Ohio versus Danielle Ham, case number CR 824-229.
All right, we need Mr. Steyer. We're ready for his preliminary hearing.
Here, I'd like to have Ms. Hand join me at the council table.
Yes,
if I could.
come down and sit with your lawyer, man.
That's you.
Good afternoon.
Good afternoon.
Mr. Guild, you're ready to proceed?
I am, Your Honor, and I believe Laura Thompson is here. Laura Thompson?
Yes.
Can you come up here, please?
Yes, sir. Thank you, Laura, because I didn't do that.
Sign your name here, please.
Come up and talk to the prosecutor.
Oh, okay, here. Where? No.
Right here.
Yes. No. Promise.
Can we approach you on it?
Yes.
You stay here.
Thank you.
the option. We're still, there's treatment. We'll come back here sometime in a week or two.
We're agreeable to that, Your Honor. Do you have a medical card of some kind?
Yeah.
Medical, Medicaid?
I didn't do that, Laura.
Okay, please don't
Okay,
talk in the
sorry.
courtroom. I'm not trying to be hateful to you. It's on the record.
Is there a charge against Ryan Edwards also?
Yes, Your Honor, there's a
Okay.
warrant for him.
Just haven't found a gun. Had him multiple times. Okay, so my understanding of what's going to take place here is we're going to let this pen here in this court while she goes to treatment.
If she's willing to do that.
She is willing.
Yeah.
And,
Can it be, can I go to like outpatient treatment?
I think what you'll need to do is get an assessment and do what the assessment says you need.
Okay.
And who are we going to get to assess her?
OVP? It's closer to where I live.
Is Brienne still here?
She said they didn't have any female vets anyway.
Okay.
They didn't have any female vets.
For wherever. As long as you can smoke. I'm a smoker.
Will, I don't know what agency. Bethesda, okay, thank you.
Okay, you want to talk with her?
Yes, Your Honor.
Let's have that happen and then we'll come back.
All right, thank you.
All right.
So she was gonna probably go back into that room back there.
Yeah, what we used to call the attorney room, I don't know what we call it. Dizzy's office.
It's the cat's room.
Yeah.
Now, the cat, there's a cat bed in there and a cat tree.
Okay, we're in recess until we can deal with that one and court's in recess.